my lord. Next week, any date convenient for my lords. Apply.
Lordship, maybe for listing of this writ petition, pending writ petition for admission next week, your lordship.
No, give a date, give date.
May
He'll give the date.
like to mention item 40, my lord. Lordship, this matter may be taken up after 2 weeks or 3 weeks.
Why?
Lordship, some difficulty on our part today, Lordship, for the petitioner.
The petitioner,
Lordship.
on the prayer for adjournment made on behalf of Mr. A.K. Bhuyan, learned counsel for the petition, list the matter
After 3 weeks, my lord.
after 3 weeks. Okay.
Wait, please, your lordship. Well, I beg to mention item number 57, my lord.
Yes.
Content case, my lord. Actually,
And we are
for the first time it is being listed, my lord. It should have been listed as motion matter, but it has been listed as orders, my lord. So my prayer is that, my lord, immediately after motion matter is over, my
Just
lord.
give me item 57. Wait, yes, next, yes, madam.
Wait, please. I like to mention for listing of this matter on the day after tomorrow, your lordship.
Day after tomorrow, you'll be the only one here. I'm not coming to court day after tomorrow.
My lord. That any
Next week. Day after tomorrow, not possible, madam, it's a holiday.
Sorry, my lord. Then it may come about 9th of this month. 9th.
New matter, new case.
Not my lord. It is I filed IA for correction of the order, your lordship, passed by your lordship.
Okay. Give a
Ninth.
9, give a 9. 9.
May it please your lordship. May it please your lordship. I beg to pray before listing this matter for admission, your lordship. As the matter is.
Date, he'll give it.
For motion, matter may be listed on Monday, lordship. There is an argument. Monday.
What is the, no, give it to him. Monday, I think, lot of.
Motion.
Okay, Monday.
May please, your lordship. Lordship, I beg to mention item number 35.
35, yes.
I will be allowed to withdraw the same.
You want to withdraw? That's withdraw.
Cause of action is not surveyed.
Okay. It can be disposed of. Mr.
H.I. Chaudhary.
Mr. H.I. Chaudhary, learned counsel for the petitioners, prays that he may be allowed to withdraw the writ petition as he has received instructions to the said effect. To stop, Mr.
B. Chaudhary, my lords, for the ONGC, my lord.
Mr. B. Chaudhary appears for the ONGC.
The matter has become infractuous.
I know. Okay. On the prayer of the, but you have not, you did not file any affidavit.
They've basically gotten the awards.
Ah.
They've challenged the tender, my lord.
Okay, they've got it.
They've gotten the contract
Okay.
arising out of the same tender.
On the prayer of Mr. H.I. Chaudhary, the writ petition dismissed as withdrawn.
Deeply already.
May please, your lordship, my lord. My lord, I have prayer for listing of an IA, my lord. This was filed long back in the month of, my lord, April, my lord. So implement of.
Long back, April is just 5 days.
My lord,
I mean,
kindly
5
list
days
it on
back.
Monday, my lord.
Huh?
Monday.
No hurry, give a date.
My lord, I beg to mention item number 52, 53, 54, 55.
Yes.
Order matters, my lord.
What do you want?
52, 53, 54, 55, 56.
Huh?
52 to 56.
Yes.
Kindly, my lord, time may be allowed 2 weeks time to file additional affidavit, my lord.
Who is for the other side? Mr. N. Ahmed. This has not been complied with.
Yes, my lord.
No, you're for the petitioner.
I am petitioner, my lord.
So-
Content matter, my lord.
What has happened? Let us see. 52 to 50. Just give me item 52. And what about that 57? What about 57? You're not,
57
yes,
is not, my lord.
57.
56, up to 56.
I know. Where is Mr. Hawk? Okay, right. Anyway, he's not here.
With regard to item 38, your lordship.
Give me item 52. So this additional affidavit has not been filed.
Yes, my lord. Yes, not fine. 2 week time may be allowed, kindly, my lord.
Mr. N. Ahmed, learned counsel for the petitioner. submits that. The petitioner requires 2 weeks' time to file additional affidavit in terms of the order dated 5/4/2023. To sub accordingly, leave this matter for 2 weeks. 52 to 56. Yes, where is the order? Where is the order?
Is judgment, my lord, this is judgment is. At this 9, my lord, over the portion will sign,
Page 9.
my lord.
Which writ petition are you, which is your writ petition?
My lord,
There are various writ petitions. Which is your writ petition?
my lord, 2656, my lord.
2656.
WPC number 2656. They are, my lord, a series, my lord.
Okay, so what is the direction?
The action was, my lord, the respondent within 30 days from the date of judgment, my lord, should inspect the work what has been already done, and remaining work should be handed over to the petitioner.
Where is that?
Eh, Just a minute. Yeah, sir, thank you. Happy days, happy days. When we have to prevent intention within the years. So we have added content. Well, at best 68, well,
Yes,
which is otherwise technical reasons we
Huh?
the respondent created after making measurement of the work so done by the contractors on the vested letter of the account.
where, which line?
My lord,
First line, second line, third line, which line? Are you
my
reading?
lord, page 68, my lord,
60?
68.
I have got it in front of me. Which line?
My lord, I am from the beginning, my lord.
Ah,
Lloyd Peter, who is, my lord, there are continuances, my lord.
Ah.
From the last 667 also, my lord. Lloyd Peter, who is otherwise technically responsible. In the peculiar circumstances of this case, the respondent PWTRD, after making measurement of the work so done by the contractors on the basis of letter of acceptance, this so and so, in respect of package number so and so.
okay, right. I heard Mr.
Yes, sir.
S. Hock, learned counsel for the petitioner, who submits that the judgment and order dated 7/2/2023, especially para 42 bracket Roman 4, small Roman 4, passed in
WC number.
WPC number 2656 of 2021, has not been complied with. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered secretary within 2 days. List the matter after 4 weeks.
May I please the lordship, my lord, in this matter, we have filed a impleading application 2 months back, my lord. So I pray for lifting any day in the next week, my lord.
He'll give a date.
With regard to item number 38, your lordship, we filed to reply and affidavit. yesterday.
You filed?
With regard to item number 38, your lordship.
Yes.
We filed to reply affidavits yesterday.
Reply
I believe-
affidavit yesterday.
Yes, I'm maybe permitted to bring it on. record.
Okay, yes.
Yeah, please, your lordship. Lord, I beg to mention for listing of a matter, Lord, on any day next week.
New matter,
No, my lord.
he'll give a date.
Lordship, I am for the petitioner in item number 50 and 51. Lordship, those matter may be adjourned for 3 weeks. Lordship,
Why?
certain developments takes place, my lord.
What are the development? Okay,
Lordship, in the meantime, the petitioner has also filed a writ petition which is listed tomorrow, Lordship, before this honorable court, Lordship. And on earlier occasion, this court also directed to file an additional affidavit, which is to be filed, Lordship,
in the contempt case,
in the contempt case,
then
Lordship,
you have not filed.
which was not filed, Lordship. Certain
Then?
documents I am to obtain from the petitioner, Lordship. Today I will get it.
You are for whom in the
I am for
contempt
the
case?
petitioner, my lord. Notice was not issued in this case.
So you have got to file additional document, additional affidavit.
document, my lord.
Then why did you not file?
I am here to receive it. Today I will receive his lordship.
Mr.
R. Karim, my lord.
R. Karim, learned counsel for the petitioner, pays for
3 weeks time, my lord.
3 weeks time to file additional affidavit in terms of the last court order
Lordship.
for stop. Praise allowed, list the matter after 3 weeks.
Oblige, your lordship.
May I please your lordship? I beg to mention for listing of a WPC 1506/2023 on 10th of May
Why?
because of his urgency, Your Honor.
What is the urgency?
Because it is a matter related to cattle market in the international border. So, yes, Your Honor.
Cattle.
Yes, Your Honor.
Okay, okay.
May I please, your lordship, I beg to mention for listing of a contempt case, my lord. Any date next week, my lord.
He'll give a date. I don't know if it can be done next week. He'll give a date. Yeah.
May I please, Lordship? Lordship, I beg to mention a matter for listing, Lordship. Matter was,
He'll give a date. For listing, he'll give a date.
May I please, lordship, I beg to mention for listing, my lord. WBC.
New matter. Is it new matter?
No, Lordship, it's an old matter. Matter pertains to election of cooperative society.
He'll give a date.
May I please, lordship, prepare for listing a WBC for admission, lord.
May it please your lordship, lordship with regard to item number 41 of today's list, your lordship.
Yes.
If lordship will have a look at the last order, lordship was supposed to be tagged along with the two writ petitions. The lordship may pray that the matter may come up together, your lordship. I'm providing with the last order. Lord.
Okay, right. Item 41. As per order dated,
45 lordship.
Huh?
I apologize, lordship. Item number 45, your lordship.
as per order dated 26/4/2023. This case was to be listed along with WPC number 5616/2018 and 57/2018.
Lordship, there's an error in that. Lordship is 5757, your lordship.
5757.
Lordship.
5757/2018. However, as the same has not been listed along with the above writ petitions, list this case along with the above writ petitions after a week.
May I please, your lordship, I pray for listing in admission, lordship, on Monday, lordship.
He'll give a date.
Lordship, I beg to mention item number 20, Lordship.
25,
23, madam.
23. Yes, what about it,
In
madam?
this case, madam, petitioner counsel has some difficulty today, madam. Madam may take up next week, madam.
You're for the petitioner,
Madam, I am not for the petitioner.
you're for the respondent.
I am for I appearing for the counsel on behalf.
Okay, who is the petitioner?
P Das, madam.
Mr.
Miss P Das.
His name is not there. Item 23.
Sorry, madam.
Yes,
My prayer is for listing, Lordship, on next week, Lordship.
new case.
No, Lordship.
He'll give a date.
My prisoner, WPC number 1562/23. It was, last question was 23/23.
So
Now, next week, it may be kindly,
I don't know next week. Just he'll give a date.
another matter, my lord. WPC number 5454.
Yes, he'll give a date. He'll give a date.
Met with the lordship. Item number 66, my lord, it's a contempt petition. And my lord, they have ordered, complied the order of the honorable court. So this petition
Okay,
will be.
item number 66.
66. Supplementary.
That is for withdrawal. It will be coming anyway. Anyway, item 66, you're right.
66,
Miss
maybe closed one.
Miss N. Saikia,
Yes, madam.
learned counsel for the petitioner submits that the contempt petition can be closed as the order has been complied with. As the order passed by this court has been complied with. In view of the prayer made by Miss N. Saikia, the contempt petition stands closed.
Obliged.
May it please your lordship.
Yes,
My lord, I have instruction to withdraw this writ petition.
okay.
My lord may also kindly record a submission that the department may be set at liberty to encash the bank guarantee, which we have already submitted to them.
They may be,
Set at liberty to encash the bank
they
guarantee.
are at liberty to, they are at liberty to encash. Who are you
My
to
lord,
tell?
we just record that for
Why?
our convenience. There's
Huh?
certain, my lord may record it for our convenience in the appellate process, my lord.
Their part, my lord.
Why is, that is their prerogative. They want to encash or they don't want to encash. Who are you to tell?
My lord, they don't want to
Kindly
pursue,
record
my lord,
that,
I have no obje- if they don't want to pursue the writ petition, then I have no objection.
Huh.
Regarding bank guarantee, my lord, it will have.
That is the prerogative, that's their prerogative. Why should we get into that? Heard, Mr.
N. Barwa.
N. Barwa, learned counsel for the petitioners, who submits that he has received instructions to withdraw the writ petition. Mr. B. Gogoi appears for the
Taxation department.
taxation department, while Miss
SCKL
SC,
for SC income.
what is your name?
Aja.
Miss Aja appears on behalf of Mr. SC KL, learned standing counsel for the
For
Union of India.
for the Union of India,
No, SCGST.
for standing counsel for the GST, for the
Central GST.
Central GS.
central GST, CGST. On the pair of Mr. N. Barwa, the writ petition stands dismissed and withdrawn.
My lord, the names of co-counsel may also be.
Huh?
Names of co-counsel may also be written.
Okay, you write Mr. N. Barwa, who else?
My lord, I have given a list.
Okay.
I'm
Please
okay.
write the name.
My lord, in this matter too, I have instruction to withdraw the petition.
Mr.
As they,
S, your name is not here.
it is there, but it's incorrectly reflected in the side of the respondent. Your Lord.
Mr. S. Day, learned counsel for the petitioners, submits that he has received instructions to withdraw the writ petition. Mr. Who is there?
And N. Boda.
Miss N. Bora for
Respondent number 4, 5, and 6.
respondents number 4, 5, and 6. Comma, who else?
2 and 3 lords.
Mr.
And Gibson.
N. Goswami for respondent number 2 and 3. And Mr. B. Gogoi for respondent number 1. Is it? Are present. The prayer of the writ petition is allowed. The writ petition is dismissed as withdrawn.
Much obliged.
Yes, they want the appointment of an independent arbitrator. What to do?
Already kept arbitrator has been
Huh?
appointed, but failed, my lord.
What?
Three for fifth arbitrator has been appointed,
Huh?
but it was he resigned his
He resigned. So what is to be done? They want an independent arbitrator. Okay, right. No one appears for the petition on call.
notice.
Full stop. The petitioner's case is that 5 arbitrators have been appointed by the respondents and they have all resigned on one ground or the other. Full stop. Accordingly, the petitioner prays for appointment of an independent arbitrator under section 11(6) of the 11(6) read with section 15 of the Arbitration and Conciliation Act 1996. First up, issue notice returnable in 3 weeks.
4
Yes.
weeks, my lord. 4 weeks.
Why?
It will go to
Mr. 4 weeks, Mr.
take it up.
AK Datta accept notice on behalf of all the
All
respondents.
the-
This is the matter of the 4 weeks. Yes,
Lordship, this matter is about the demarcation of land. Annexure A, page 9 is the application which was presented in the year of 2019. And it was registered also,
under the act,
yes. Lordship, thereafter, no decision has been taken.
why didn't you file an appeal?
Appeal is to be filed if they take any decision thereafter. I can.
No. Who said that? What jurisprudence is there? If they have not filed an appeal, it's the same like your Right to Information Act. If they do not take a decision on your request for information, you file an appeal.
Yeah,
Same
but
here,
you
there is a
can't-
provision.
And my submission is that Annexure B, Lordship, peruse the office memorandum. It is issued as per the section 4 of the Right to Public Service Act, which mandates that any application for demarcation, if it is submitted, then has to be disclosed within a period of
Or
30
1 month.
days.
1 month, 30 days.
30 days. He may reject or he may accept my application, but I am not on that. I am not praying that my application shall be allowed. But decision is to be taken in term of that office memorandum. So Lordship, it may be disposed by directing the circle officer, the decision may be taken in term of that office memorandum.
But that period has already gone.
A period has gone. That is why I am before the court.
So you file an appeal when there is a provision for appeal.
That is page 13 of the.
Page number 13, Lordship.
Yes, you go in appeal, simple as that. You go in appeal. But one thing is that you see, you all are not deciding what to do. It becomes very difficult. He'll file an appeal, nothing will be done. You file a fresh application.
Yes.
Lordship,
You file a fresh application.
Lordship, yes, I will file and Lordship, this observation may be given that I will file a fresh application.
Okay, heard, Mr.
FZ Mojumdar.
Huh?
FZ Mojumdar.
FZ Mazumdar, learned counsel for the petitioners who submits that the petitioners had submitted an application for demarcation of a plot of land which they had purchased on 18/11/2009 by the registered sale deed. The application was presented to the Assistant Settlement Officer of Bali Jana Revenue Circle of Golpara District. Full stop. Thereafter, Miss Case number 245/2019 was registered. Full stop. The circle officer, is it?
Yes, Lord.
The circle officer was to take a decision on the petitioner's application for demarcation of the plot of land. However, the same has not been done till date. Full stop. He submits that though the application had been submitted on 27/2/2019, the respondents have not acted upon the same till date. Just say that instead. Instead, you have same two things twice. Same thing twice. Put the second one in. Also. Mr. N. Goswami, learned counsel for the
2, 3 and 4.
2, 3 and 4, and Miss
G. Hazarika.
G. Hazarika for
Question number 1.
respondent number 1. Submit that the petitioner may submit a that though an appellate that though an appeal provision is provided in the what is the act?
Some right to public.
Huh?
Right to
Some
Public Service Act.
Right to Public Service Act
2012.
2012, comma. The inaction of the respondents may be due to the fact that maybe due to the fact that the application that though there is a appeal provision in the so-and-so act, comma, a fresh application, but the case was already registered.
This case was in.
Case has been registered.
Without keeping pending this case, a new application, they may not dispose. Then what will about this petition is already good. Yes, Lord.
Then you file appeal. You file an appeal.
I may withdraw. Lordship, if you give me liberty, this application, I
Okay.
will withdraw and I.
Okay. The petitioner may withdraw Miss Case number 245/2019 and file a fresh application for demarcation of his land, which can be decided by the circle officer. Full stop. On the consent of the parties, comma, the petitioner is given the liberty to withdraw Miss Case number 245/2019, comma, provided the same has not provided the same has not been finalized or decided till date. Full stop. Thereafter, the petitioner may file a fresh application for demarcation of his land, and the circle officer would have to take a decision on the same in terms of the Right to Public Services Act 2012. The writ petition is accordingly disposed of.
In terms of this office memorandum dated 27 December 2000.
In terms of the act and the office memorandum dated
27 December 2020,
27 December 2020,
published by the
issued by the
Revenue and Disaster Management
Revenue and Disaster Management
Department to the Government of Assam.
Department, Government of Assam.
I beg your lordship. Although in this matter.
Yes, madam.
Lordship, I've received instruction, Lordship, on 4/4/2023 issue, notice was issued, Lordship, to the petitioner for, regarding mutation of their land.
Then,
Now, my lord, in 2019, this application was filed for
so
mutation.
now they are
Yes,
going
my
to do it.
Let them file the affidavit, my lord, because in 2019, they also.
No, so the petitioners have been asked to do what?
Appear, in.
Give me that, give me the notice. Have you given a copy to them? No.
My lord, I have received a copy.
Oh, you have received a
Yes,
copy.
my lord. The same thing happened in 2019. Thereafter, my lord, the matter was in cold storage. That's why, my lord, my prayer is that your lordship will issue notice and let them file affidavit and let us see what is the progress, my lord.
But you are directed to appear on 15/5.
Yes. Will appear, my lord.
You appear. Okay, right. Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Miss
And Doctor.
N. Datta, submits that the petitioner, having requested for mutation of his name in the land records, the respondents have till date not completed the exercise. Full stop. He, however, submits that subsequent to the filing of the present writ petition, the petitioner has been issued a notice dated 4/4/2023 by the Joint Secretary in charge CALA, Department of Revenue, Karbi Anglong, Autonomous Council, DIFU, directing the petitioner to appear.
Petitioner as well as the, my lord, the respondents in the.
Directing the petitioner and the respondents to appear on 15/5/2023 before the said authority. Full stop. Mr. M.K. Chowdhury submits that the petitioner will appear on the said date. Full stop. Issue notice returnable in 4 weeks, 5 weeks, 5 weeks. Ms. S. Kemprai, accept notice on behalf of.
Respondent.
My lord, all the respondents.
But what is there to keep pending? There's nothing to decide now.
No,
They
what happened, my lord? Earlier also notice was issued. I appeared, the respondents did not appear. They were.
kept it pending. Okay. Ms. Accept notice on your respondents number. Karbi Anglong, one, Chief Executive, I think 1, 2. I think all. I think all. I think all the respondents. First stop. This is the matter on. This is May already, 15/5, say 4 weeks. Huh? This is the matter, give a date in June. You bring the latest, the up-to-date status of the issue, okay? List the matter answer, so to enable, hey, yes, to enable Ms. S. Kemprai to give the latest update on the grievance of the petition.
Obliged.
Well, there are two writ petitions. Subsequent one was filed by me. What had happened, my lord, there was a tender notice for supply of school furniture to a school, my lord, it's called Adarsha Vidyalaya at Talgaon. That tender, my lord, would find at page 26.
Which one is your case?
My lord,
Which one are you reading? 4 or 5?
for item 4, my lord. 2189.
Item 4, yes,
My lord may come to page 26.
yes,
This is the requisition for
yes,
submission. Then, my lord, 27 clause 11, my lord.
clause 11, yes,
Lordship, there is a thing that samples, my lord, may be called for, has to be submitted.
yes.
Accordingly, my lord, tenders were opened. I was L2, he was L1, my lord. There was a difference around 5 lakh rupees in the costing. Then, my lord, at page 32, we both were directed to supply the samples.
Yes,
And we supplied the samples. My lord would find the assessment at page 33,
yes,
wherein, my lord, he did not, made, my lord, supply of a few items, which
Mm.
were also not found to be,
no samples provided. No.
others, there were
Give me
15
give me item 5.
there were around, my lord, 15 items. He provided for.
So what happened? He was
Then, my lord, what
disqualified.
had happened was, it was directed to be, my samples were accepted and the supplies were directed to be made to me. There was a logjam, while it was not being done. All of a sudden, my lord,
Where is the order asking you to supply?
my lord, no, that order was not come. The sampling was made at page 34, my lord would find.
Yes,
Final findings.
yes,
During our technical verification, our team has found so-and-so has produced all samples, a sample of all items as per letter of so-and-so, but JMK, that is the respondent, has not submitted sample at all of all items. During the technical verification, we have found only 5 samples of JMK, that is the respondent. We have found MJS has produced all samples as per specification properly. In other hand, so-and-so has produced only 5 numbers of sample, which are not shown maintaining the proper specification as directed by the so-and-so. Hence, comparison between the two parties during our sample verification
for
provided
final
by
consideration.
lordship.
Now has the final consideration been
What,
done?
what they have done, what has happened, my lord, final consideration was pending. How I came before your lordship, 11-4, my lord would find at page 36, a notice was again issued to me, 11-4,
Yes.
saying that I'll have to submit the samples again on the next day.
So you have come on
I
against this.
came here, but when I came before this honorable court, I came to learn, my lord, that the private respondent had already approached this honorable.
Yes,
And this honorable court in that item number 3, my lord would
5.
find. 5, my lord, sorry. My lord would find an order dated 31-3, my lord.
Yes. Has given liberty to the
My lord, how it has been worded, my lord would see. Towards the end, my lord.
you come to the third paragraph.
It is, my lord would say, the court is of the opinion that the petitioner be afforded another opportunity to place the sample of the supplies which he proposes to make within a period of
So
10
it has
days. from
decided
today.
the entire issue.
Lordship.
Now you go to the division bench. What remains for me to decide?
No, my lord. What had happened, then I filed this case. Both these matters were directed to be tagged and placed today.
No, whatever it is,
Lordship,
the import of the order pass
lordship,
by the other L1.
lordship.
In the case of L1, is that the court is of the opinion that the petitioner be afforded with another opportunity to place the sample of the supplies
Lordship,
within so and so, and there will be a fresh inspection assessment of the supply made decision will be
Lordship.
taken.
And my lord,
So now what is there for this court to decide?
no, my lord, what had happened here, on the reason why he came up before my lord, if my lord just goes a bit above the order, said that he had limited time with him to place the samples.
Oh, that may be, but the fact remains
he
that
placed.
this decision has already been made.
No, this, my lord, there is an order in my case on 21/4/2023. The last line, my lord would see. Any action taken in this regard shall be subject to further order that may be passed on 3/5/23.
Look, you go at best is I think division bench. I say how can I, because this is the
Because
order.
my problem was, my lord, I was not implemented as a party there. my lord.
No, the problem is
And that was at interim direction.
same judge. Anyway, he was not aware of these cases.
No, we were not aware, my lord. When we
You all
came,
were not aware. So then,
But I
and
pointed-
neither was the court aware that he had passed an order in a similar case like this.
no, my lord, what had happened, I pointed it out, my lord. It's reflected in my order. I pointed it out. Because when I served the copy on the state, they told me. Immediately, my lord, my friends took out the copy and then, my lord, I placed it before the court, my lord. In the last line, my lord would find that, my lord, in the body of
Okay.
the order in my case. The honorable court has recorded that, my lord. Third paragraph, my lord. So, Naya so-and-so has pointed out that the opposite direction appears to be in compliance of an order dated so-and-so passed by this court, which was instituted by the other bidder. And in that case, the present petitioner was.
Oh,
not
but then how can he's I don't think this. I'm finding it difficult to.
My lord, we'll have the order dated 31/3/23 for a minute.
Yes,
My lord, will come to the third paragraph, my lord.
yes.
The learned counsel for the petitioner submits that apart from the fact that very less time was granted for making the supplies of the sample, the recommendation is not on the basis of quality, but certain lack of fitting which could not be done because of constraint of time. Then my lord will skip the next paragraph. Be that as it may, this court is of the opinion that dispute may not be required to be adjudicated in view of the directions proposed to be passed. The court is of the opinion that the petitioner be afforded with another opportunity to place the sample of the supplies which he proposes to make within a period of 10 days. And there will be a fresh inspection assessment of the supply made and a decision would be taken. It is needless to state that such decision be taken independently and fairly and the outcome be informed to this court by the next date fixed.
Correct.
In view of the stipulation may make supply within a period of above and decision be taken thereof within a period of 2 weeks. This was passed on 31/3. I was informed on 11 to supply on 12th.
No, whatever it is, I'm saying
Lordship.
that the, Asha, you want some more time to supply.
Because
That is your case.
not even
Okay,
given
okay, okay. So your case is that you need some time to make further
big
supply.
and
No,
my lord, they
For
will-
samples.
samples.
Okay, okay.
And they will, my lord,
You're not
take a
challenging this order.
I'm not challenging that order. My
So
lord,
only thing is that you want some, since he has been
because
given,
if
he has been given 10 days, you should be given some more days
a
also.
week time, my lord. And till that time, my lord, whatever action pursuant to that
Mr.
order has been
Bhattakur.
taken has to be interpreted.
I am.
Since it is for the benefit of the school, why not give him also some more time, since some time has been given to you?
Is bit late, your lordship. What
Why?
has happened in the meantime, your lordship, work order was issued on 19/4/2023 to in favor of the writ petitioner and the other writ petition, your lordship. And he has made some
Another writ
supplement.
petition?
The item number 5, your lordship.
4, 5, you're in 5.
No, I am for the, your lordship, school.
Actually, you're for the school. You're for the school.
School.
You have given work order to to Mr. Nair.
No,
No.
other one.
Okay, you're the other one.
In the meantime, since.
Oh, already.
And work order has been given. Some supplies, my instruction is, my lord, the benches, desks have not even been supplied. till-
Bench and
Even-
desk has not yet been supplied.
Then,
your
my lord,
lordship,
he
but
couldn't
rest
make
some
that
of the
supply till date, my lord.
Almirahs and
In
etc.
spite of the orders and the supply order on 19.
And in
So
fact,
has he made any, have you made any supply?
desk and bench, they have not made any, your lord, supply.
Desk and bench you have
Some
not
of
made.
the
Major-
Almirahs, etc.
Because
they
he
have
does
supplied.
not have, he does not have the quality. my lord. Lordship, that was the inter se comparison made. Direction, that was never placed before this honorable.
But you should have gone to division bench now, because of this subsequent order. Now, and you see, once the work order has been issued, now we cannot go back.
No,
to
no,
a
we
position-
have made a challenge to that work order, my lord, in my writ petition, my lord. In the second. writ
Maybe.
petition. And
maybe-
all done surreptitiously, my lord.
Yeah,
All done surreptitiously. The DC gets it.
probably. No, but then you see, the problem is that this court in the other case has already given opportunity to the petitioner therein to submit fresh samples, and fresh decision should be taken by the authorities.
And should
Now
be placed
they-
before
now-
this honorable court.
And whatever it is, they have taken a decision now.
Lordship. And my lord, one factor, that decision was directed to be placed before your lordship. My lord will see the hurry. They have issued work orders.
You have not placed it before the.
No.
Lordship,
I came up, my lord, before
your
your lordship.
lordship, this has come up, your lordship, for the first time after the initial order.
No, but then this
Item
other,
number-
this other case,
Not item number 4, item number 5.
I agree, but item number 5, you were supposed to place the decision before this.
Lordship, that is what, your lordship, I have brought.
On
Yeah,
This is
bro.
what has been provided to me. The
Today.
work order. Yes, today, your lordship, by WhatsApp, this has been provided to me.
Let us see.
This is the work order, your lordship, and the rest, your lordship, physical inspection team.
Now, what
report.
is to be done? What can be done?
Only thing is, my lord, that whatever they have done, my lord will have to undo it, direct them to make a comparison again, and then proceed with the matter. My that aspect was never placed before your lordship.
In fact, your lordship, last occasion when this order was passed, your lordship, by the honorable single judge, your lordship, coordinate bench, your lordship, I have placed the entire record, your lordship, to me, your lordship, and I have pointed out all those things.
Anyway, so desk and chair.
Chairs, desk and benches have.
Desk and
desk and
benches have not been supplied.
So desk and benches, let there be no supply for the time.
Lordship. Lordship.
I leave it to your lordship, but your lordship, only thing, your lordship, we have some.
Huh?
We have some urgency, your lordship, so
Correct.
far as the school is concerned,
Correct.
your lordship, we are suffering. Whether he gets or the other one gets, your lordship, we.
My
don't
lord
have
would
an-
see the.
But
first
why
thing.
do you need to file fresh samples? Submit fresh samples.
No, my samples were there. His samples were together compared. His samples were found to be of inferior quality.
Now he is given a
He has
better
given, but
quality.
there is no inter-se comparison, my lord.
Where is the comparison?
Lordship, that is what I have, your lordship.
This comparison, there's
So
nothing
for a
here,
physical
nothing.
inspection team report on furniture. So
There is nothing. Oh, why he has been chosen over the other?
because his rate is, your lordship, otherwise lower.
No, initially, my lord,
But
both were found.
this is not reflected here.
Lordship, rate so far as that will be in the, your lordship, the file, your lordship, that I will have to bring your lordship.
My lord, initially he's.
It will be-
Yes, yes. Okay, Mr. Goswami, yes. What?
Correct factors on block place recording on the report. Initially, lordship, the principal has invited NIT. That NIT, I am become L1. Work order has not been issued to me. That order has been cancelled. Therefore, fresh NIT has been issued, where I am become again L1. Work order has not been issued to me. They have taken sample from 2% L1 and L2. As per lordship, the guidelines, this sample can be taken from L1 only. No sample can be taken. Work order should be issued to the person who is the L1. And thereafter, lordship,
Well, sample has to be taken from L1 only.
no, sample have to be taken. No sample have to be taken. As per guideline, they have to,
No sample has to be taken.
No.
So you can supply whatever you want.
lordship, kindly see the guidelines, page 23 of the petition.
Your repetition.
Lordship,
Yes.
page 26.
Yes.
Lordship will kindly see clause D.
Yes.
Guidelines for procurement of furniture, lordship, got it?
Yeah.
Clause D, purchase order will be issued to the lowest bidder. I am the lowest bidder. If qualified as per terms and conditions of the quotation for letter.
Clause 4.
On delivery of the furniture at the school, same shall be inspected if any found item to be inferior to the specification or defective will be rejected. Such item will be replaced, should be conformed to the laid down specification. So when I made a supply, if any inferior quality is found,
No, there is nothing wrong if the comparison is made prior to that. There is nothing wrong.
nothing
That has
wrong.
been
There is-
followed in
there-
respect of all
We
these
have got no
cases.
case that way.
No, lordship, I am
Anyway, we'll fix it for another date.
lordship will kindly say two things.
We'll fix it for another date. No time now.
Lordship will kindly see one thing. I am the L1. Earlier tender process was cancelled to accommodate him. That is why I am approached this honorable court.
No, where is that? Where does it show?
Kindly see. Lordship, earlier NIT at page 70.
Yes.
Page 16 is the earlier NIT.
Yes.
Lordship, that is the NIT for the same furniture
That NIT gone.
on 15/7/2022.
Yes.
Lordship will find that NIT was cancelled by the authority
Yes.
when I am the L1.
Yes.
Only on the ground that.
So you didn't challenge that.
No, I have
You have
said.
not challenged that.
No,
You have
no,
not
that
challenged-
they have-
No, okay, we'll decide the issue. Right. Heard Mr. UKNR, learned senior counsel for the petitioner in WPC number 2189/2023. Also heard Mr. SK Goswami, learned counsel for the petitioner in WPC number 8353/2022. The challenge, have you made a challenge to the work order?
Yes, ma'am.
The challenge is with regard to NIT dated 2010-2022 for supply of furnitures to the Adarsha Vidyalaya, Dalgaon, Pusta. The petitioners, the petitioner in WPC 8353/2022 was found to be L2, while the petitioner in WPC 8353/2022 was found to be L1. Pusta. In the comparison statement made with regard to the sample furnitures, the furniture samples submitted by the two petitioners, it was found that the petitioner in 2189/2023 had supplied samples for all the items, while the petitioner in 8353/22 had had supplied furniture samples only for desk cum bench and for teacher. However, no samples had been provided for
Other item.
11 out of the 50, no, 10 out of the 15 furniture samples to be submitted. Full stop.
Only on the lordship record, only on the ground that I have been given only 1 day's time to give the supply.
Full stop. Full stop.
Only 1 day's
Uh,
time.
accordingly, recommendation had been made to accept the tender submitted by the petitioner in WPC 2189/2023. Full stop. Next para. The petitioner in 8353/2022 filed WPC number 8353/2022, stating that he had been given only 1 day's time.
We have received WhatsApp message 3 days back. Thereafter, lordship, only Sunday and Saturday.
He had been given only 2 days' time to submit furniture samples. And this court, in its order dated 31/3/2023, passed in WPC 8353/2022, directed the respondents to afford another opportunity to the petitioner in 8353/22 to place furniture samples which he proposed to make in terms of the NIT. Full stop. Consequent to the above, the petitioner the petitioner in WPC 8353/22 supplied the furniture samples, and work order has accordingly
That
been
has been
issued.
approved.
Huh?
That has been approved.
And that has been, and the same being approved, comma, work order has been issued in favor of the petitioner in WPC 8353/2022. Next paragraph. The grievance of the petitioner in WPC 2189/2023 is that this court, in its order dated 31/3/2023, passed in WPC 8353/22, had directed that any decision to be taken that the decision to be taken for for supply of the furniture was to be made fairly, and the same was to be informed, and the same was to be, and then the court was supposed to, and this court was to be informed of the same. Full stop. The petitioners the petitioner in WPC 2189/2023 submits that the said decision has not been informed to this court as directed in the order dated 31/3/2023, passed in WPC 8353/2022. Full stop. That's all. That's of course. That's all. Full stop. Mr. Mr. S. Bhattacharya, learned counsel appearing for the school, shall produce the records on the next date. He shall also give a copy of the document submitted to this court today to Mr. Yukenar, the learned counsel for the petition WPC 2189/2023. This is the matter on.
No further supplies. What is supply? No.
Right. As it has been stated by this by Mr. S. Bhattacharya that desk and bench have not been furnished by the petitioner in WPC 8353/2022, the supply of the said furnitures shall not be made till the next week.
Date may be fixed.
List the matter on, give a date.
This month itself. We are in some urgency.
When do you want?
It's after 2 weeks, my lord.
2 weeks.
Give a date.
Nice.
Lordship, I have not been provided a copy of the petition. That it was.
Please give copy.
Either way, we will have to. We will exchange, my lord.
Apply.
Yes, what is the case?
May I please, Lordship, in this case, petitioner is a meat producing company, Lordship.
Milk producing company.
Company, Lordship. Petitioner is restrained from transporting livestock from outside the state, Lordship.
Restricted from transporting
The livestock, Lordship.
livestock.
Livestock, lawfully transporting, Lordship.
Where are, why? So where are the documents required? What are the documents required for transporting?
Lordship, may kindly come to page 14, Lordship, Annexure B, that is the
Yes,
Letter issued by the Director Dairy Development Assam Lordship to the Commissioner Department of Animal Husbandry and Veterinary Transportation Lordship requesting him to allow for West Bengal Lordship to Assam.
yes, what is the problem? But
Subsequently,
this is to the West Bengal government.
to allow for through as West Bengal Lordship, what happens in cattle.
So has the Commissioner, Department of Animal Husbandry and Veterinary, West Bengal, allowed it? Where is that order?
They allow Lordship and
Where?
subsequent was.
Where is their letter?
They are not disturbing Lordship, but in Assam Lordship part, from Cooperative part Lordship, the police Lordship. Earlier occasion also Lordship
Okay.
detained Buffalo's Lordship, then
Who is not allowing?
and Superintendent of Police Cooperative Lordship.
Why? Yes,
I have the instruction law. There is some
Okay.
criminal cases pending law against the petitioner law.
Huh?
There is some cases pending.
Maybe. So what?
That has become infraction. Earlier occasion, they detained Lordship Buffalo's. We approached this honorable court passed interim order.
That's a
Lordship,
different issue.
and
Right,
released
heard Mr. M.K.
MK
Hussain,
Hussain, Lordship.
learned counsel for the petitioner, who submits that the petitioner is a milk producing company having valid documents for transportation of buffaloes, cattle and cows from outside Assam into Assam. From outside into Assam for milking purposes. Full stop. He, however, submits that the petitioner has been prohibited from transporting the said cattle into Assam by the respondent number,
9 Lordship, more but 7 Lordship.
by the respondent number 7.
7.
That is the SP Kokraja. Mr. N. Goswami accept notice, issue notice returnable in 2 weeks. Mr. N. Goswami accept notice on behalf of respondents number
2, 6 and 7.
2, 6 and 7. While whose
Pending counsel, veterinary department,
Yes,
but their names not shown.
Name not shown.
what is his name?
Copy of sub Lordship.
What is his name?
RP Poran. Poran.
M. Kotoki. MS M. Kotoki.
While Miss M. Kotagi accept notice on behalf of respondents number. You call Miss M. Kotagi. Where is she?
Right.
You have no idea.
I'll serve copy Lordship.
While Miss M. Kotagi accept notice on behalf of the
One.
Animal Husbandry and Veterinary Department.
Yes.
List the matter after 2 weeks to enable list the matter on, give a date. List the matter on 19 to enable Mr. N. Goswami to obtain instructions as to why the respondent number 7 is prohibiting the transportation of cattle into the state of Assam.
Extra copy will be provided. Lord.
I'll.
The petitioner, your lordship, is a contractor and I've been paid a bill amount of rupees 12,95,258, but I'm yet to be paid an amount of rupees 17,11,748. Your lordship.
We issue notice? Or what? Right. Mr.
T. Dury.
T. Dury, learned counsel for the petitioner, submits that the respondent authorities have released rupees 12,95,258 out of the total contractual bill amount of rupees 30,07,006. The petitioner's counsel submits that the respondent authorities should be directed to release the outstanding amount of rupees 17,11,748. Issue notice returnable in 4 weeks. Mr.
I.M. Das.
R.M. Das accept notice on behalf of
All the respondents.
all the respondents. This is the matter after 4 weeks to enable the respondents' counsel to obtain instructions
I'm deeply.
and file affidavit if necessary.
Worship, the petition here is a class 1 contractor of the APWD building, and he is also working as a food vendor and giving catering service for Assam University in Silchar Medical College and etc. And Lordship, during on 25/5/2021, Lordship, he was given a
So
temporary.
we issue notice.
Lordship, I should notice that this is the because blacklisting was done.
Okay, right.
as per
Lordship,
proposal.
there's
Huh?
interim prayer, Lordship.
What interim period? No interim
He is a
period.
blacklisted.
No interim period. You have been blacklisted.
Lordship,
We don't know. We have to
Lord-
hear the other side.
Lordship, we are.
And you have been given, you have been issued notice, you
Yes,
have been heard also.
Yes, but
That
Lordship,
was
we got
notice
given
also
the report of
specifically
the.
mentioned,
Ah.
Lordship, regarding the intention of the authority to blacklisting. That was also specifically mentioned. So Lordship may issue notice at this case, we will reply, Lordship.
All right, heard Mr.
A Bhattacharya.
A. Bhattacharya, learned counsel for the petitioner, who submits that the petitioner is a class 1 bracket A contractor of the APWD building and is also engaged in the business of catering and supply of food items to government organizations, comma, private sector as well as public sector bodies. Full stop. He submits that the petitioner has been unfairly blacklisted. Provide speaking order dated 13/4/2023 issued by the Deputy Commissioner, Kachar Silchar. Full stop. Issue notice returnable in 2 weeks.
Lordship,
Mr. K. Gogoi accepts notice on behalf of
Lordship, I am for 1, 2, 3, and 4, Lordship.
1, 2, 3, and 4.
And
Joint
five-
Director, Health,
five for health, Lordship, B over Lordship.
while Mr. B. Gogoi accepts notice on behalf of respondent number 5. The petitioners shall, no, the respondents council shall obtain instructions and file affidavit by the next date.
Lordship, some interim
Lordship,
product.
the-
Status quo will do. Lordship already.
What status quo?
Assam University already issued one notice that we, as we have been blacklisted, we have been asked to vacate the girls hostel number 4, where we are providing master, the food services, Lordship. Already on status quo as on today.
Lordship, already he is blacklisted, Lordship. He is challenging the blacklisted.
No, no, which is the order?
Lordship, I have received this on 26. That copy is not that clear, Lordship.
It is not here, not part of the record. Where is the
Subsequently,
file?
Lordship, we have been.
You file a affidavit, you file a subsequent affidavit for that, because that is by different authority.
Yes, Lordship.
So this is by DC.
Your Lordship,
You file a different application, IA, for that, okay?
Alright,
List the matter after 2 weeks, that's all.
Please, Your Lordship.
Yes,
Lordship, this matter is conducted by Senior Counsel Mr. Kija Mohammed. He is on legs on court number 5 for the time being.
next.
Made please, Your Lordship. Lordship, these petitioners are poor but meritorious students belonging to minority community. And the government of India, Ministry of Minority Affairs, has issued a scheme saying most metric scholarship, which are to be given to the students who are poor, belonging to minority community and pursuing some technical courses, Your Lordship. Now, these petitioners, they are pursuing 2 years diploma courses in pharmacy. And Your Lordship, an advertisement for application was issued by the state government of Assam at page number 18, seeking applications for those who are intending to get the scholarship, Your Lordship. That application has to be filed through NSP, National Scholarship Portal. Once the application is filed, Your Lordship, then the concerned institute to which they are studying, they are registered with the Ministry of Minority Affairs. They have a login. They will log into the system and they will verify the documents. If it is found that it is okay, they will approve, and then it will go to the district nodal officer who should approve. Who shall also do the same, Your Lordship. Now, in this case, what happened? The petitioners applied and their application was duly verified by the institute, but the district nodal officer rejected, Your Lordship, at page number 20.
He responded number?
6, respondent number 5 and 6. 5, I have imputed him as an official respondent, and 6 by name also I have imputed because of his action, Your Lordship. At page 20, Your Lordship will see from the online status, it can be found. Page 20, this is application ID and application status. Application is permanently rejected by the district nodal officer. Below, Your Lordship will see-
Where? Application is permanently rejected.
Why?
Rejected. So we have to ask with the issue notice.
It will, because it will take time in them, then let them take instruction, since it is a scholarship matter, Your Lordship, and if notice is issued and subsequently.
It's been rejected. Once it's rejected, they need time.
Lordship will say that it was duly verified by the institute,
Maybe,
but the
maybe,
And I have,
Maybe.
Lordship, the page 20 down below.
Huh?
That 20 down below, documents not submitted, Lordship.
that is their case, that documents not submitted. We appeared before him, we submitted the documents, and on this frivolous ground that documents not submitted. All the documents are uploaded in the website, your lordship.
Let
Let them take instruction, and then
Lordship.
your lordship, if required, your lordship may issue notice.
Mr.
MH Loskar, your lordship.
M.H. Laskar, learned counsel for the petitioners, submits that though the petitioners had applied for post-metric
Scholarship.
scholarship for the year 2022-2023, the district nodal officer had rejected the same, even though the applications had been verified by the
Concerned institute.
concerned institute. What institute is that?
This is one Shifa Pharmacist Institute, registered with the
By the,
Shifa Pharmacist Institute.
where is that? Where have you written that? By the Shifa, SHIFA. Shifa Pharmacy Institute. That's all. Mr. N. Goswami, appearing for the
2, 3, 4, and 5, Lordship.
respondents number 2 to 5, shall obtain instructions as to why the petitioner's applications have been rejected. Though, no, but it has already been written, the bottom they say that no document submitted then.
So therefore, your lordship, we have specifically stated in paragraph number 6, we appeared before him, we submitted the documents, and the reason for his paragraph 6, lordship. will-
Anyway, let him obtain instructions. Then we'll direct that.
Lordship.
List the matter after 2 weeks.
Date may be fixed, your lordship, any date, your lordship.
Give a date.
I am deeply obliged, lordship.
May it please your lordship, this item is read by Mr. K. Ruiz, Nixon Court number 10, lordship. Kindly pass over the matter for the time being.
Actually, in the earlier one, what have we said that before list the matter, we have said that as to why the applications have been rejected, it may be stated here that the reason for rejection of the petitioner's application is non-submission of document as reflected in page 20 of the writ petition. That's right. You just say any other reason for rejection of the, okay.
Lordship, in this case, Lordship, we are led by Mr. Ken Choudhury, Senior Advocate. Matter may pass over for the time being, Lordship.
Next. Yes.
May I please as a lordship? Lord, the matter relates to, my lord, election of a cooperative society, my lord. My lord, what has happened, my lord, initially in the year 2018, my lord, on 29/5/2018, the election for the last term for 5 years was held. My lord. And the date for, my lord, constitution of the board of directors, my lord, was fixed on 11/7/2018.
11/7/2018.
2018, my lord, for the constitution of the board of directors. Now, my lords, a writ petition was moved challenging this constitution of 11/7/2018 before this honorable court. And this honorable court, my lord, on 9/7/2018 was pleased to stay that my lord, the constitution of the board of directors, my lord, although it was constituted, but it cannot be given into effect due to the stay order in operation, my lord. Accordingly, my lord, that stay order was continued.
And if the order was passed on 9/7
My lord,
and the constitution of the board was supposed to be made on 11/7,
my lord.
and where is the question of the board having been constituted after the order of the court?
Yes, my lord, may be pleased to peruse the stay order, my lord. I have annexed, my lord, at page.
No, just now you said
My lord.
that the board was to be constituted on 11/7.
Yes, my lord. For that, my lord, I beg to draw my lordship's kind attention to the interim, the stay order, my lord. Was page number. At page 18, my lord, may be pleased to find. Let the meeting be held on 11/7/2018 as scheduled, but approval of the same shall not be granted by the Assistant Register of
Ah,
Cooperative.
so approval shall not be
Yes, yes,
granted.
my lord, this honorable court allowed, but my lord, we could not.
Correct. So
Yes,
say that,
yes,
you
my lord.
are
Now,
changing the
this-
facts of the
yes,
case
yes,
otherwise.
exactly, my lord. Now, my lord, this stay order is in operation and continued, my lord, and this honorable court, my lord, was pleased to dispose of the said writ petition, my lord.
Yes,
At page 21, my lord, a detail and a categorical finding is here, my lord, by this honorable court. I beg to draw your lordships can straight away to the operative part, my lord.
yes.
My lord, may be pleased to skip the. huh? Yes, my lord, page 24. The petitioner prayed for setting aside the notice, paragraph 8, my lord, I am reading, my lord. In WPC number so and so, the petitioner has prayed for setting aside the notice dated 8/7/2018. This writ petition was filed on 9/7/2018 from Annexer 4, appended to IS civil number so and so. It is seen that in the meantime, by the board members had held a meeting on 11/7/2018 and elite the board members had elected the respondent number 5 in WPC number as president of the Poop Bedbury Samavai Samiti Limited. This action having not been assailed, and as such, when the notice has already been given effect to holding the board, the court is constrained to hold that the petitioner is not entitled to any relief. The petitioner is found to have suppressed the material fact regarding the existence of clause 23 co of the bylaws of the Poop Bedbury Samavai Samiti Limited, which envisages the 15-member board. Hence, the court is constrained to hold that the petitioner has not come with clean hands, and as such, he is found not entitled to equitable relief under Article 226 of the Constitution of India. These two writ petitions fall on this count also. As a result of the discussion above, these two writ petition fails and the same is dismissed. However, leaving the parties to bear their own course, needless to mention the interim order dated passed by this as extended from time to time stands vacated.
My lord, there are similar matters that have been pending. Notices have gone already. So this, in this matter also notice may go and the matters may be.
So your case is that,
My lord,
so approval for that meeting, approval of that meeting minutes,
my lord,
could take place only after the judgment was passed in this case.
my lord. And we could take up the. my
The,
lord, in charge
your
of the
post, your
office.
charge,
Exactly, my lord.
only after 20.
Exactly, my lord.
And
Now, so
accordingly,
therefore the-
you should have a till 25.
Yes, my lord.
That is your case.
Exactly my case.
So we'll issue notice. As I
My
said.
lord, only thing is that on, if the, my lord, on 28/5, my lord, this of paragraph 13, my lord, of kindly, my lord.
Where is that order?
Huh? Uh-huh.
The statute is quite clear, 5 years.
This is to be listed on 10-4.
My lord,
What has happened on 10-4?
I'm not aware, my lord. I think on the, there's been no progress. Affidavits have been filed. There's a senior standing counsel who has already appeared. I'm appearing on behalf of Ms. MD Vora, my lord.
No,
So-
because you see, now the thing is that their term is going to end on 29.
My lord.
29. But according to them, it should end only from the date of approval, I think.
Exactly, my lord.
Correct. But you have been functioning as a board since when?
My lord, on, immediately after the 15/10 to 2020, my lord. 15/10/2020.
So only from 15th.
My lord,
In that case, notice may go, the matter may sum up.
Before that date.
Before that, my lord.
my lord,
Before that date, let it come on.
My lord.
Heard, Mr.
my lord. A.R. Bhuyam.
A.R. Bhuyan, learned counsel for the petitioner, who submits that the Board of Directors of Poop Bedbury Samavai Samiti Limited,
My lord.
which is a registered cooperative society, had been elected in the election held on 29/5/2018. The BOD could not administer, the BOD could not function due to the operation of the interim order dated 9/7/2018, passed in WPC 4364/2018. Full stop. WPC 4364/2018, having been dismissed by order dated 7/10/2020, the BOD started functioning only from 15/10/2020. The petitioner's case is that they should be allowed to function as BOD till 6/10/2025.
My lord.
And the BOD cannot be dissolved. It cannot be made to function only till 29/5/2008. Yeah,
28, my lord.
28/5/2023.
My lord.
Issue notice returnable in 3 weeks. 3 weeks, Mr.
RB Goswami, madam.
RB Goswami, accept notice on behalf of,
All the respondents, my lord, but I'm appearing on behalf of Miss MD Bora.
on behalf of, no, appears on behalf of Mr.
Miss MD Bora.
Miss MD Bora,
For-
counsel for all the respondents. List the matter on 27. 29 it will finish.
28 is the election, my lord. Supposed to be. Can it be on?
List the matter on 26.
26, my lord?
26. 26/5.
My lord, may I observe it on?
To enable the respondents' counsel to obtain instructions. Notice is also issued on the prayer for an interim order, which will be decided on the next date. Let them get some.
Yes, yes.
Because it appears they have a case.
Right.
Okay, there is one thing I have to raise now. I will try to come back by 1:45. I just got an appointment with the doctor, so I'll come back around 1:45. Okay. Unfortunately, my doctor is old man and he's got fixed timings.
My lord.
I have no problem on that. Another 2 bus there, my lord, contract will be expired, my lord, in the month of June. So now,
No, you've got 3.
3, my lord,
So one bus is up till 27
my lord,
and 2 buses are going to expire in June.
is expiring in June, my lord. But they are in a very good condition, my lord. They are all requirement they fulfill. Now, my lord, they float a NIT. In NIT, that NIT is asked to deprive me, my lord. There are 2 conditions of the NIT, my lord. I am agreed by that. So that 2 condition, my lord. Page 31, my lord. But my performance is very good, my lord. That's why earlier they given me extension, my lord. Your lordship kindly see that NIT at page 29, my lord. So page 28, my lord.
Yes.
Page 28, my lord. And 11 portion, my lord. Page 11 portion, page 30, my lord. Serial number 1, subclause E.
Yes.
The vehicle that proposed to be provided must not be older than 3 years. So, my lord, that condition is, my lord, I agree, my lord. And another condition, my lord, that is page 31, serial number 2B, seat capacity of 30 to 35 seats. My lord, my bus is capacity is 40, my lord, more than that. So, my lord, for that effect, my lord, I file a representation. Because this condition, at least as a existing contractor, my lord, that they can waive out also. So that is also pending, my lord. They have not considered it till today. Page 37, annexure 8.
Yes.
So that is, of course, that is their discussion. But my lord, if my lord, I am strong enough, it is good enough, and condition of the bus is very good, my lord.
So we'll ask them to take a decision.
My lord, that is my pair, only pair, my lord. Otherwise, my lord, legally I don't have any right.
Mr. Gogoi,
Lordship,
anything to say? We take a decision on the petitioner's representation.
lordship, direct to dispose of the representation, lordship.
Since my performance is very good last 10 years, my lord. That is my case.
Heard Mr. T.J. Mahanta, learned senior counsel, assisted by Mr.
D. Borwa.
D. Barma. for the for the petition assisted by Mrs. Silsa. The petitioner's case is that he has got 3 buses which are plying under contract with the Jorhat Institute of Science and Technology, Sotai, Jorhat. The petitioner's counsel submits that out of the 3 buses, one of the buses is having a contract with the Jorhat Institute of Science and Technology till the year 2007, to the 2027, while the contract period for the other 2 buses are going to end in the month of June 2023. The petitioner's counsel submits that NIT dated 28/3/23 had been issued by the Jorhat Institute of Science and Technology from contractors / travel agents for running their buses with the institute. He submits that in view of the conditions laid down
1E and
at clause 1 bracket E and clause 2 bracket B, the petitioner cannot participate in the tender process inasmuch as his buses are over 3 years old and the seating capacity of his buses
is 40.
are up to 40 seats. He submits that the petitioner has submitted a representation dated 4/4/2023 to the respondent number 3 to consider, to take a decision, to consider his representation and to enable him to participate
3 and 4 same person.
in the tender process with his existing buses. What is that? What is the thing? What? 3 or 4?
4 same person.
3 and 4.
3
and 4. Mr. K, he accordingly submits that the writ petition can be disposed of if a direction is issued to the respondent number 4 to take a decision. 3 and 4 to take a decision on the petitioner's representation dated 4/4/2023. First up, Mr. K. Gogoi, learned counsel for the respondents.
Within a week, because my last date of
Okay.
submission is 9.
Mr. K. Gogoi, learned counsel for the respondent, submit that he has no objection to the prayer made by the petitioner's counsel. Next paragraph. In view of the consent of the parties, the respondent number 3 and 4 is directed to take a decision on the petitioner's representation dated 4/4/23 within a period of 1 week from the date of receipt of a copy of this order, along with a copy of the representation dated 4/4/2023. The writ petition accordingly disposed of.
May I please, your lordship?
Yes, what is your case?
My lord, the writ petitioner is a aged tribal lady. So she had purchased one plot of land, my lord. And thereafter she applied for mutation. Accordingly, mutation was granted. She was in possession. All of a sudden, this respondent number 7 is a private respondent. He has started construction. So she being aggrieved, she rushed to the respondent number 5, the circle officer. Then she again rushed to the police officer, respondent number 6. She lodged complaint before the police as well as before the circle officer for causing one demarcation of the land. Since there is a boundary line going,
encroaching upon her own land, a substantial portion of her land. So what she wanted a limited prayer, that demarcation be caused, and thereafter, if he is the owner of the land. And moreover, one more angle is there, my lord. The person, respondent number 7, is not a pactator of the adjoining plot of land. Adjoining plot of land is covered by tag number 129. And he's 129. And my lord, petitioner's land is 128.
100.
And 129 is, my lord, situated on the western side of 128. And he has started construction on the western side of the petitioner's land, encroaching upon a substantial portion of it. But my lord, the petitioner is before your lordship.
Where is your representation for letter for demarcation of land?
Demarcation of land is available. At page 52, this is a translated version.
Page 52.
Page 52. And actually the application was written in vernacular language. It is available at page 53.
This was on 27/3/23.
Yes, my lord.
So 1 month period has not ended. Ended. April.
Prior to that, my lord, on 23rd also, she made a prayer before the circle officer. The thing is that this petition has not been entertained at all. The notice is supposed to be given to the adjoining plot owners. That has not been initiated at all.
What about that right to what Public Services Act 2012 that has not been acted upon? So you didn't file a repeal.
My lord, I am before your lordship questioning the deliberate inaction of this respondent authority.
But there is a appeal provision in the right to Public Services Act 2012.
The period is also probably over, as because
No,
in between-
period of filing appeal is not over. If your representation is not decided within 1 month, you can file an appeal.
Very well, but thing is that there are twofold angles involved. There is the illegal construction going on, unless and until that is not intervened. So the whole purpose of causing the demarcation will get defeated. They will
No.
already encroach upon. Thereafter, civil litigation will be the only remedy, my lord. And in case we go.
Okay, anyway, right. Heard, Mr.
R. Sharma.
R. Sharma. Who is appearing for the other side? Yes, what do you say?
In fact, from the case history, we can find out it is a case of land grabbing. So criminal conditions are involved. So he or have filed an FIR also. Now, as regard the demarcation, if at all demarcation is done, then there cannot be any dispute. So if at all the demarcation process has been delayed, then definitely the appeal provision has to attract. So he hasn't exhausted those remedies.
No, but you see, they're not doing it. Let the demarcation be done. We direct them to do demarcation.
If demarcation is done.
So then at least for him, it will become easier to
Yes.
pursue his case with the police. FIR, what will they say? They do not know whose land is where.
Ultimately, a spot verification.
Has to be
demarcation
done.
Of the area.
Heard Mr. So-and-so, well said. Learned counsel for the petitioner who submits that the petitioner is the absolute owner and possessor of land measuring 1 bighra 15 lechas covered by DAG number 128 of KP Patta number 5 of Revenue Village Sati Karpa Moza Chayani under Palash Bari Revenue Circle, Kamrup District, Assam, which he had purchased from the original Patadar by registered sale deed number 5/2023. The petitioner's further case is that the respondent number 7 has started constructing a boundary wall by encroaching upon a substantial portion of the petitioner's land on the western side. The petitioner's counsel submits that the western side of DAG number 128 is covered by DAG number 129. Full stop. Though the respondent number 7 is not the owner of dock number, is not the owner of dock number 128, he has, 129, he has constructed the boundary wall from the western side. Full stop. The petitioner's grievance is that though the petitioner had requested demarcation of her land with the Palash Bari Revenue Circle Officer by letter dated 27/3/2023, and a complaint had also been issued to the police,
To the police.
to the
Officer in charge, Polasbari Police Station.
to the officer in charge Palash Bari Police Station by letter dated 28/3/2023. No action has been taken by the police. Full stop. Next para, the petitioner's counsel submits that the present writ petition can be disposed of if a direction is issued to the Palash Bari Circle Officer to take a decision on the petitioner's representation dated 23/3/2023.
Regarding my lord. Sorry to, regarding the construction work.
No, let them take that. No,
part of
that we cannot go into, Mr. Counsel. We do not know. We do not know whether what you're telling is the truth. You see, for that we'd have to issue notice. We do not know. They will conduct demarcation.
Lordship may, in case your lordship deems it proper, may issue notice and keep the box in
No,
appeal
no,
till the
no, no.
returning date.
No, then you go in appeal. Then you go in
No,
appeal.
no, no, in that case, okay, disposal will.
So what have I said?
The petitioner's counsel submits that the present writ petition can be disposed of if a direction is issued to the Polashbari Circle Officer to take a decision on the petitioner's
Representation for demarcation of the petitioner's land. First stop. Mr. S. Barwa, learned counsel for
respondent number 13456.
13456 and Ms. G. Hazarika. For point number 2, submit that they have got no objection with the prayer made by the petitioner's counsel. Full stop. In view of the consent of the parties, this petition is disposed of with a direction to the respondent number.
To the respondent number 5.
To the respondent number 5 to take a decision on the petitioner's representation / application dated 27/3/2023 for demarcation of her land covered by DAG number 128 of KP Kata number 5 of 2025, KP number 5, within a period of 1 month from the date of receipt of a certified copy of this order.
My lord, one angle is there. If suppose the construction is there and they have already encroached. upon
That
my
they
land,
will decide. We're not going to that.
Because in that
We
case,
cannot speculate at this juncture. Demarcation, let the demarcation first be there.
that could be subject to the.
The writ petition is accordingly disposed of. Otherwise, you can add one thing. It is needless to add that if the demarcation is in favor of the petitioner, further necessary order / action should be should be taken by the respondent authorities. If it is in your favor.
Number 6.
Wait, please, Your Lordship.
Item?
Item 11, my lord.
Yes.
Yes. My lord, what had happened in this case, Directorate of Social Welfare, Government of Assam, my lord, in 21-22, invited and tendered for supply of, my lord, this melamine wares, my lord, basically glass, dishes, plates, bowls, to be supplied to the Anganwadi.
For the year 21-22.
22. Now, what had happened, my lord, amongst others, the petitioner was also given some work along with respondents number 4 to 7. Now, for the year, my lord, 22-23, as yes, 22-23, my lord, what they did, they extended the contract without calling for any tender. Now, in 22-23, the petitioner was not given any work. On the contrary, my lord, 4 to 7 were given. Now, the petitioner's concern is, my lord, now for the present year, my lord, they have floated tender that they will take to
For
logical.
22-24.
23-24. Now they have issued tender that they will take a call on it in accordance with law. I'm not troubling on logic with that. So what had happened, my lord? I am apart from a supplier, I'm also manufacturer of my lord melamine wares, my lord. Now, my lord, they have submitted the tender 427 based on my specification. Now, after getting the order for 22-23, my lord, they did not purchase our products, my lord. Instead, my lord, they are supplying, inferior quality product. My lord, it's a very serious matter, my lord, because.
But then that period has ended, 22-23 has ended.
I'm not on that, my lord. I'm praying for directing an inquiry into the matter, my lord. Why I'm saying so, my lord? Lordship will kindly, I'm not seeking the work, my lord. Here I'm seeking an inquiry. If your lordship will kindly permit me to place paragraph, my lord, 18B, my lord. Please come to paragraph 18 for a minute.
Yes.
At page 12, that the respondent numbers 4 to 7 have participated in the tender dated 16/9/21 on the basis of authorization of the petitioner firm and based on MOU executed with the petitioner firm, and therefore they were found bound to follow product manufactured by petitioner. However, respondents number 4 to 7 have not procured the entire product for both the financial year 21-22 and 22-23 from the petitioner, and they have supplied some low-grade quality of melamine product to the department for which petitioner should not be held. Tomorrow, my lord, as per the government terms, my lord, they are supplying my.
This is between you and the respondent.
No, I'm coming to it, my lord. No, yes, with me also, but it also includes an element of public interest. That is why I'm invoking the public law amendment. Now, my lord will kindly come to paragraph 20. Paragraph 20, my lord, page 13. That the petitioner states that the product supplied in terms of NIT dated, if not good quality, would affect the health of small children and there is even risk of causing cancer, and therefore petitioner is more concerned about quality of the supply and praise this honorable court to direct chief secretary respond to cause an inquiry into the matter. Now the question is, my lord, one, you are not inviting tender, all right, that also you may do in a given case, that also will not question. But why, my lord, some inferior quality products are being supplied?
My samples have been approved.
And my lord, it is my sample which have been approved. Tomorrow, if there is a criminal prosecution, my lord, I will be faulted.
Maybe you should file an PIL
No, my lord.
for this.
No, my lord.
No.
This case involves.
No right of yours has been violated.
My right has been violated, my lord.
Why?
Tomorrow, there is a threatened imminent violation of right is
No,
involved.
because according to
That's
you,
why I'm praying for a mandamus. Lordship knows when a mandamus can be issued, when there is a threatened imminent violation of a right. So Lordship will kindly appreciate, it's a government department.
have you made any representation to this effect to the authorities? Where is that?
Huh?
Let us see a representation.
It's
not there.
Then
No, my
how
lord.
can you come?
No,
No.
it's
How
not-
how
no.
can you come straight away to this court
No, my lord.
without first approaching the authorities with regard to your allegations that these are inferior quality? Where have you asked them that why have you taken inferior quality of materials? Where have you said that?
Or in that case, no, my lord, that statement is there. We have not approached the authority. In that case, can it be done this way, my lord? Lordship will file a representation, they will consider. We'll file a representation. Whatever point we have hesitated in the petition, will hesitate in the representation, the authority will consider.
You file it first. You file it. Why should we take a decision on that? You file it. You withdraw with liberty to file a
My
representation
lord will
first.
kindly appreciate one aspect of the matter. The test report is in respect of our product. They are not supplied because, my lord, why I'm saying so?
I know the problem is that they were supplying your products. Supposed to. But for 22-23, you have not been given the supply orders, only your agent.
If I would have been agreed, my lord, I would have come immediately. I am coming now. Now even the tender for 23-24 is going.
But quality of products, where can you just,
No, my lord.
this is a PIL.
Yes, no, lordship is correct, my lord. I can approach PIL also. But here, since there is an element of public interest.
You
I can
file
file-
you first go to the authorities. First of all, no right of yours has been violated.
In that case, the lordships can always direct us to approach the authority. We will file, my lord. Lordship will make that.
We can
record.
make an observation that this writ petition is not
With this,
material
with
as.
this, with this of the, allegations, we may approach the.
No, I won't say that. I'll just say that you have not come, you have approached this court without approaching the authorities first. Then you can approach them.
No, then my lord, lordship will have to say that because I have not approached, therefore I have to go.
Huh? Yes. Alternative remedy has not been availed of. You have come directly to the court.
No, my lord. My humble submission is very simple. Had it been a case where I would have said the work should be given to me, that is a different aspect. That which I am not asking for. All that I am saying is, instead of my product, they are using somebody. That means, my lord, they are supplying product which
We don't know. We don't know. No document of yours. No plea. No representation. One small representation of yours. Suddenly you have come to the court with this. At least write to them. Say that why have you taken inferior quality? You are supposed to take this quality.
That's why I'm saying, my lord, I'll approach the authority.
You approach. I'm not going to direct that they should consider. I'll just say that the writ petition is not maintainable as alternative remedy.
Well, I'm doing this petition, my
Yes.
lord. Will give us liberty.
Right. Mr. K. N. Chaudhary, learned senior counsel for the petitioner, please that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. N. Goswami appears for the
123, Lord.
correspondence number 2 and 3.
123.
123. That's all.
Lord.
The prayer of the petition's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for.
And my lord, kindly give us liberty to approach the authority.
With liberty to approach the
Authority.
appropriate forum.
Competent authority.
Appropriate forum.
Yes.
Appropriate forum.
Okay. Yeah. My lord, in this case, what had happened? The petitioner was on to manufacturing of, my lord, razors, shaving cream and all. The unit is located in the state of Maharashtra, my lord. Now what had
Unit
happened?
is located in Maharashtra.
Now what had happened? No, the cause of action there is in here.
Oh.
Now what had happened, my lord? There was a business transfer agreement between petitioner and the respondent number 3. In terms of that agreement, my lord, the business was taken over by respondent number 3. Now let me narrate the fact, then I'll come to the, my lord, 1 or 2 the NHLs. Now what had happened, my lord? When we were the owner, my lord, of this particular unit, there was an industrial reference.
Where is your factories? Here in Assam.
Yes, no, factories are in, my lord, Maharashtra. But here, my lord, the reference was taken place in state of Assam because some employment regarding in the state of Assam. Yes. Now, respondent number 3 and 4 are the workmen, and respondent number 2 is the labor.
4 and 5 are the workmen.
Yes, sorry, my lord. Respondent number 4 and 5. Yes. Now, my lord, 2 is the, my lord, union. Now, what had happened during the time this particular reference was going on with regard to respondent number 4 and 5.
With the petitioner.
Yes. Now, my lord, what had happened in the business transfer agreement, there was a specific provision that all the liability, including the contingent liability, was taken over by respondent number 3. Now, if your lordship should kindly come to page number 25, my lord. This is the BTA.
Page
25.
25.
Yes, it starts, but I'll have your lordship's kind attention to page 41. Transferor is, my lord, petitioner number 1, and transferee is the petitioner number 3. 6.2.3.
6.2.3.
Yes. The transferee shall on and from the transfer date take over all the employees of the transferor employed for the purpose of business with continuity of service on condition of service not less favorable enjoyed by the employer prior to the transfer date, and such service shall be reckoned from the respective date of employment with the transfer in accordance with the terms of their employment in accordance with the applicable laws. This is important. The transferee shall be responsible for complying with applicable laws in connection with employment of the employees with effect from the transfer date and shall pay be responsible for fulfillment of all liabilities, including but without limitation, payment of gratuity, bonus, etc., etc. Then my lord will kindly come to page number 72. This is the schedule of the contingent litigation
But in
liability.
this 41,
My lord, yes,
it talks only of the employees, doesn't talk about those employees which have been sacked, terminated.
no, it is there, my lord, page 72. I'm coming,
72,
yes, page 72. Kindly come to that middle portion, my lord, schedule VMPL contingent litigation liabilities. Has a logic got it? Now, my lord will kindly come to page 74. Serial number 72.
Yes.
72, application number 6 of this is the reference number. So, my lord, it was intended that they will take over everything. So, liability was 14,25,000. Then, my lord will kindly come to page number 127. This is the impugned award. In the first para, somewhere in the middle, my lord, sentence starting with, so I have decided.
Yes.
Yes. So I have decided issue number 1 against the management. At the same time, in view of the decision in preliminary issue number 1, 2, and 3, and in issue number 1 of the reference case, in view of the decision therein, I hold that workmen are entitled to reinstatement with full back wages. If they are not in service, monetary benefits shall be given till their resignation from the date of dismissal, that is so and so. And if anybody is still in living idle, he is to be or they are to be reinstated forthwith back wages. If by this date they are not in service of the company, monetary benefits are also. So this was the award, my lord.
But where is the amount? This amount page 72.
No, my lord, reinstatement with all back wages. That is the order.
Yes, that is 74.
Yes.
Where do you get this? How do you get this 14,25,000? It is, this has
My
been
lord-
made after the award.
No, no, it was before the award.
Before the
Award
award.
happened subsequently. It was contingent liability.
Okay.
Yes. Then my lord will kindly come to page number 128. What had happened? Since my lord, the award was not being followed by the petitioner, therefore this notice was issued to us by the labor officer.
Just a minute. Let me go to 127.
Yes.
So I have decided issue number again the same.
Entitled to reinstatement with full back wages.
So who is 1, 2, 3?
Preliminary issue, my lord.
Okay, there's no.
No.
Who are the
preliminary
parties?
issue.
Who are the parties there? Okay, you are the party.
Yes, yes,
Okay, yes.
Yes.
Okay.
Yes.
Then,
Then please come to page 128.
yes.
Now, this is a letter written by labor officer. It says in closing here is a complaint received from General Secretary of the Union addressed to the Labor Commissioner, which speaks for itself. And now, I therefore propose to hold a joint inquiry cum discussion in the office of the undersigned. You are therefore asked to attend the same.
Yes.
Then, my lord, we replied at page 129.
Yes.
Now, at page 130, if your lordship will kindly come.
Yes.
Last para. In the light of the facts explained above, this is to request your good office to kindly take up the matter appropriately with the transferring company, Supermax Personal Care Private Limited, and accordingly discharge the addressee company, so and so. Now, pursuant to this, my lord, what had happened? The union, my lord, filed an application before the court for withdrawal of this application. Eventually, it was withdrawn.
Which application?
My lord, the execution petition.
Okay.
Now that has been withdrawn, that order lordships will get at page 150. Since we said, my lord, that we are not responsible to transfer a company, therefore the union, my lord, at page 150, last para.
Yes.
In view of the above, petition for withdrawal is allowed with liberty to the decree holder to file appropriate fresh application for execution of the award passed in by the labor court in reference case number 6 of 2009. Now, my lord, what had happened? They have filed an application under section 33(2)(c). Now, we are agreed by that. We are not responsible, my lord. Now,
So what has been done?
there's one more aspect, my lord. There were other litigations also in the state, in the state of Maharashtra, my lord. There are two orders which I'd like to show, my lord, where the labor court accepted the plea and my lord passed the award against respondent number 3. That I am trying to show, my lord. At page 167, a part of the order in one case. At page 167, my lord.
Yes,
Line about 1, 2, 4, 5, 6, 7, 8, 9. Line about 9 from bottom.
yes.
First party number 1 transferred the business to first party number 2 on 30th December 2010. The copy of the
Okay, so
relevant.
the award the payment has
Now
to be
wait.
made by the number 2.
The question is, my lord, since the whole thing has been transferred, the liability was taken. Where is the question of we being responsible?
So, but where is the application? Where is the order passed or some notice issued to you?
Which one, my lord?
The 33 and the second.
Yes,
33.
that is there. Sir. The 33 is at page number 152, my lord. (152). Section 33C2, management of Withdrawal Metallics Private Limited, represented as managing director. Notice has been issued to us. As per order dated, you are hereby actually appear before this court.
Where is
on
this order dated 21/11?
21/11. order is not there, my lord. Anyway, my lord, now notice has been issued to us. Now, our humble submission is, my lord, this proceeding, the petitioner is not maintaining. Let them proceed against the, my lord, respondent number 3.
No, that is all right.
Yes.
That too we
Yes.
can get.
Yes.
But why don't you go and tell them this fact?
Who's my-
That you
No, my
please
lord.
proceed against.
No, they will not do, my lord.
But at
No,
least
no,
make.
no,
at
prima
least make-
facie it is a jurisdictional error, my lord.
No, but then who are the parties there in this case?
No, my lord, Bidur Sarkar, the respondent number 4. Respondent number 4, my lord.
No, so I mean out here
Sorry, respondent number 5.
respondent number 3 is not a party in this.
That
This
we
is-
don't know, my lord. May not be not. Maybe not.
No, what I'm saying is, since you have come here, why don't you go there also? And
No, my lord, I have challenged the award also.
tell you.
Yes, that's the whole thing. This is the subsequent part. I have also challenged the award. Award is not maintainable qua the petitioner. We have challenged in this proceeding, we have challenged the award also.
Yes.
I'm putting respondent number 1,
Huh?
notice to go lodge because I'm.
Okay, right. Heard Mr. K. N. Chaudhary, learned senior counsel for the petitioner, who submits that the petitioner had transferred its business to the respondent number 3. White business transfer agreement, bracket BTA, dated 30/12/2010. Full stop. In terms of clause 6.2.3 of the said BTA, the respondent number 3 took over all the employees of the petitioner on and from the date of the BTA. Further, all the liabilities and contingent liabilities were also taken over by the respondent number 3. Full stop. In this regard,
Page 74, my
the
lord.
learned counsel for the petitioner has referred to serial number 72 of the schedule 4 VMPL contingent litigation liabilities, which is at page 74 of the petition. This application 6, let us see, application 6 is with regard to one person or two persons?
I couldn't follow, my lord. This was for 2 person, my lord.
2 persons.
But the
Okay.
cause was
So
put forward
4
by
and
the
5 were
union
there.
for 4 and 5
Okay, first stop.
by 2.
You got it, no? Page 20, so 24 the writ petition, full stop. The petitioner's counsel submits that despite all the liabilities and contingent liabilities now having been taken over by the respondent number 3, the Labor Court, Guwahati, provided its award dated 28/1/2014, passed in reference case number 6 of 2009, has directed that the workmen were entitled to reinstatement with full, no, the workmen were to be paid their full monetary benefit
They are to be reinstated with full back pay.
after reinstatement. Full stop. By the petitioner. Full stop. The petitioner's counsel submits that in view of the fact that submits that in similar cases that had been decided by the labor court in Maharashtra, the payment of liabilities and contingent liabilities on the basis of awards made by the labor courts have been fastened upon the respondent number 3. First of, as such, the petitioner cannot be made liable with regard to the payment of service benefits of the respondent number 4 and 5, as the same is the responsibility of the respondent number 3. First of, issue notice returnable in 4 weeks. Mr. N. Goswami accept notice on behalf of respondent number 1. Petitioner takes steps for service of notice upon the respondents number 2 to 4, 5 by a registered post with AD within 2 days. List the matter after 4 weeks. In the interim, before that, before we say issue notice, we just say one thing. The petitioner's counsel submits that in view of the above facts, the proceedings initiated against the petitioner under section 33-C bracket 2 of the Industrial Disputes Act, 1947, in case number 01/2022 and case number 2 of 2022 before the Learned Labor Court, Guwahati, should be stayed. Then you write, okay, in the interim, the proceedings in case number 1 of 2022 and case number 2 of 2022 under section 33(c)(2) of the Industrial Disputes Act 1947.
As well as the award, my lord.
It's the same thing once this goes, once this stopped.
No, award is also is
Okay.
under challenge, my lord.
No, but you have not prayed for that.
I pray.
No,
Yes, my lord.
no,
My lord.
no, you have not prayed for
For
that.
in respect of interim, not. Okay.
Pending before the Learned Labor Court, Guwahati shall remain state
Deep. Not labor code, no,
till the next returnable date. List the
Deep.
matter after 4 weeks.
My lord.
Okay, lunch.
Hope it is all right, my lord.
Huh?
The back problem.
You want it now?
Not, no, today, we should be not, this is count within a week, 15.
Okay, you want to upgrade it, item 38,
Today, not today.
not today. Okay, item 38.
If it's possible on 15th or 17th.
You're for the petitioners.
Petition.
My lord, I am for the respondent.
Yes, you're for the, and what about any private respondents?
All private respondents.
On behalf of 10, 13, 15 and 16, Your Honor.
The private respondents are there.
So pleadings are complete.
Yes. Yes, sir.
Please,
Your Honor, I would like to please put that we have not been served a copy of the reply that they have filed. affidavit in reply to our opposition.
Then you give the affidavit in reply.
Today's respondents,
10, 13, 15 and
10, 15.
Okay, right.
We'll do it.
On the prayer of Mr. M.Z. Ahmed, learned counsel for the petitioner, senior counsel for the petitioner. Leaves the matter when?
15 to 17, if it's possible.
When the pleadings are complete, it's better to have it on a hearing date, I think.
16,
16th.
measure.
Then you give the affidavit. Yes, right.
I have received.
Today. You have received.
Obliged, madam.
This is with regard to the award of contracts. So have you finished working? Or have you
No, no.
started the work?
This started.
we have started, Your Honor.
You have started,
Yes, Your Honor. It's a tender for transport of petroleum products, Your Honor.
you have started.
Yes, Your
Measure.
Honor. Much obliged, Your Honor.
This item? 15. Yes, what is your case?
Lordship, there is your lordship.
Compensation amount not given.
Lordship, what happened? I am the owner of land measuring. 2 bigha 1 kata 12 plus your lordship, which was purchased by registered sale deed number 269309 dated 7/12/09. And out of this land, your lordship, government acquired farmland that is measuring.
So you have not been given the compensation amount.
Lordship,
Correct.
lordship,
That is your
for the
case.
land, for the
So-
Zirat and other things, they have given the compensation.
What is Zirat?
For the
What
land-
is Zirat? What is Zirat?
Zirat means your lordship, trees, small structures, all these things, your lordship, come within the definition of Zirat.
What about
So-
a house?
Lordship,
House building?
there was no building, your
No,
lordship.
no, will building come under Zirat?
Building, your lordship, it comes separate heading, that is, it is as building, your lordship, RCC building or like that. But so far the other small things are concerned, your lordship, this trees, creepers and other hearts and stuff.
Correct.
your lordship.
Heard, Mr.
Yes, Ali, your lordship.
S. Ali, learned counsel for the petitioner who submits that the petitioner's plot of land covered by DAG number 334 of KP Patta number 56 of village Gauripur, Maluk Kathal, Muza, Sila Sundari Khopa, Kamrup district, was acquired by the government of Assam in connection with LA case number 18/2018, wherein the petitioner's award was reflected at serial number 56. The petitioner's counsel submits that the compensation amount of rupees 27,36,876.37 has not been given to the petitioner.
For the land.
Naturally, compensation also for the land has not been given to the petitioner. Though
Compensation
the
for
Zirat
Zirat.
amount of rupees 7,41,360 has been given. Issue notice returnable in 4 weeks. Who accepts?
I appear for respondent number 2 and 3.
Mr.
As Borwa for 2 and 3.
S. Barwa appears for respondent 2 and 3 and Ms. G. Hazarika appears for
Respondent number 1, Lord.
1. Who is for? Who is
Pri-
for?
There is a complaint in fact.
Huh?
Because of the complaint, the amount of the compensation amount has been held up.
So isn't there, under what law has it been acquired?
Lordship, under the act, your lordship, right to fair compensation and transparency in land acquisition.
Then
regulation.
is there an authority to decide to
2030.
whom? Is there an authority under the said act to decide who should be given the compensation?
Lordship, it is to be given to the owner, your lordship. I am the owner.
Who is to decide who is the owner?
It is the land acquisition officer will decide, your lordship.
So under what section?
That is section, your lordship, that is 64 is there and 23, 27, 26 and 27, your lordship.
In that
There's so
case,
many
why don't
provisions.
you approach the competent authority? There is a statutory authority. Why have you come to this court?
Lordship, this is the land acquisition, but we repeatedly, your lordship, filed representation that it should be given to me because I am the owner of the land. According to them, your
Give me the
lordship,
fair, right to fair compensation.
there is a complaint. That's why it is not given to me.
Mr. Counsel, you see, always in acquisition matters, there are always people claiming land. Okay, and there is an authority to decide who should be given the set compensation amount. Now, you please tell me, where is the provision?
For the authority, your lordship, so far there is a complaint. That's why we can't disburse the amount. That is the ground, your lordship, not.
But they have to decide who is to be given. High court cannot decide. The questions of fact.
No, your lordship, this honorable court has the jurisdiction to decide because I am the owner.
We don't know.
I am the interested person.
What is the complaint? What does the complaint say?
Complaint that he claims that he is the owner of the land.
That is what I'm saying.
Right.
Now, how
But
do we know?
without any basis, your lordship. No basis, your lordship. Because I am a recorded partner that I have purchased my registered sale deed, your lordship. Got possession, my name has been mutated, your lordship. Everything is in my favor. That's why, your lordship, let them file the affidavit, your lordship. Ultimately, if your lordship finds that it should be decided by some other authority, it is different matter, your lordship. As on that, your lordship, let them file affidavit in reply. Let us see.
In the 1894 Act, you see, section 18 was there for reference. Now,
Previously.
here, where is the
That is-
provision here?
Now it is section 64, your lordship.
64.
64.
Reference to authority. Then why don't you make an application under section 64?
Lordship, it is not covered by that provision, your lordship. That is with respect to the, your lordship, amount of compensation, your lordship.
Just a minute.
Quantum of compensation. But this is a matter, your lordship, I am ready to accept it.
Any person interested, you are ready to accept, the other person is also ready to accept.
Lordship, let them show, your lordship, what is their right, your lordship, that how they are interested.
Wait a minute. Who will decide the issue? Yes, Mr. Counsel. There has to be a authority to decide the issue.
Well, affidavit is question.
Huh?
In fact, the deputy commissioner seems to be the appellate authority.
Where, under which provision?
Let me get with the instruction, Lordship. Can it be taken on another day?
You see, because it has to be there.
Yes.
Okay, what have I said? What have I said? The last sentence?
Issue notice returnable in 4 weeks. Mr. Esperua, learned counsel appearing for respondent number 23 and Mr. G. Hazarika, learned counsel for respondent number 1.
First up, petitioner takes steps for service of notice upon the respondent number 4. Stop. The learned counsel for the party shall apprise this court as to whether there is an alternative remedy available under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013. This is the matter after.
I have a fair lordship. Our name has not been reflected in the cause list and we have not served a copy of the writ petition lordship. So we have made party as a response number one.
You have,
the
you have
copy
not
has
given
been
them
served.
copies of the writ petition.
Copies, your lordship. Although we'll serve copy.
We have not been served.
State.
Revenue,
State.
standing council for revenue.
No, we have served copy, your lordship, today.
They have served
Respondent
the
number
government
1 to
advocate
3, your lordship.
1, 2, 3.
They are the government of Assam, your lordship, this land acquisition officer, deputy commissioner, these are the 3 respondents. So for private respondent is concerned, I'll have to take a step.
Mr. Council, you see, the various departments in the government of Assam have got different councils.
Oh, we have served copy, your lordship.
They have served to the government advocate lordship. They have not served to us.
You served, we served 1 copy to the Mrs. D. Hazarika.
And our name may be reflected in the copy.
Okay, right, Miss, leave the matter after 4 weeks. The petitioner's council shall serve a copy of the writ petition to Ms. G. Hazarika.
Like standing council.
Your standing council revenue
Revenue and research.
within the course of the day.
Lordship.
Petitioner takes steps within 2 days, huh? For service of this. This is the matter of the court.
Keep your blessing.
My pleasure, Lordship. Lordship, the petitioners herein are nationals of Myanmar, Lordship. Lordship, the facts of the case is such that, Lordship, they had, going to the religious persecution in their home country, Lordship. They had fled to India,
Religious persecution.
Lordship.
Where religious persecution?
Lordship,
I don't believe in that.
Lordship, we have annexed, Lordship, newspaper reports to the effect as well.
Okay, what religion are the petitioners?
Lordship, Christianity, Lordship.
Christian.
Lordship.
And there's a religious persecution in Burma
In Burma, Lordship.
of Christians.
Lordship, because they are the 6% minorities, Lordship. They are
No,
only
no,
for
no.
6%.
They're
Lordship,
having a wrong facts.
Lordship, there are.
But there is a civil war going on, that much I understand, but not religious persecution of Christian. There was of Muslim,
Lordship,
that much I know. Only.
Lordship, we have stated, owing to, as per newspaper reports as well, Lordship, with the particular facts, which state that there was.
There are over 30,000 refugees in Mizoram, we know.
Yes, yes,
And we are in the border, we know that.
yes, Lordship.
And I was in a border village around a few weeks back,
Lordship,
where there are number of
Lordship,
refugees.
Lordship,
For the first time I'm hearing this.
Lordship, so Lordship.
Anyway, you have said it. But that is not the issue. The
Lordship, we-
issue is they were foreign, the issue is they are foreigners
They are foreigners.
and they have been caught here.
Lordship,
They have been sentenced.
Lordship,
They have undergone their
Undergone,
sentence,
Lordship.
finished.
finish, Lordship.
Now they have got to be deported.
Lordship,
Correct.
Lordship,
Now, so the deportation, is it being done or not?
Lordship, currently they are lodged in detention center, Lordship, and at
They're not they are in the,
in the detention camp at Matia, Lordship, the newly, the Lordship.
after completion of the
after
sentence,
completion of the
sentence.
sentence, Lordship. Now, Lordship, the issue is currently like this, Lordship, because owing to the problems which they are facing here, they have written a representation to the authorities both in Assam government and to the Mizoram government.
To do what?
Lordship, for transferring them to any jail in the state of Mizoram.
Why should they go to jail?
Lordship, to any detention camp or any jail. in
They've
the state of
already undergone the
Lordship,
sentence.
because we are not aware as to whether any detention center is presently functioning or that. So we pray that either to any jail or detention center on the ground that, Lordship. In Assam, Lordship, they are facing difficulties because the language is not known to any.
Yes,
Well, I'm appealing for ED on behalf of the ED.
you have appearing for?
On behalf of the ED for state of Mizoram.
Yes,
There are no detention centers in Mizoram.
but there are shelters provided in the
Yes,
state.
shelters provided. I will take instructions whether they can accommodate 17 more because they're already about.
How many persons?
17, 17.
17.
Lordship, at page 44, Lordship.
But where were you going?
Lordship, we were going on our way to Delhi to obtain refugee status from the Union government. In the meantime, we were.
Actually, what they do is, they go to US, most of them. And they get this asylum out there. And there's a sizable community of Burmese people in the US. And they're very easily given this asylum status. refugee status. In fact, they are given so easily. I do not know if it's true, but I believe some Mizos also pretended to be Myanmar refugees and settled there. So,
Lordship, the Mizoram government by communication that 17/1/23.
who is for the state of Assam?
If your Lordship kindly comes to page 44 for a moment, Lordship. Lordship, the Mizoram government had stated that they are ready to
At that
accept
time,
three of
there
them.
are only 3 of them. Now
Three
there
of
are
them.
17 of them.
Yes, Lord.
Mr. Counsel, where is the state of Assam? Yes. Are you, what is your plan? You're going to keep these Burmese people after they have completed their sentence in detention centers for how long? Till kingdom come or what?
They need to be deported now.
Huh?
They need to be deported now by the union government.
You have got to take a stand somewhere. You cannot just keep them in detention centers. Either you deport them back into Myanmar. Have you tried to push them back into the country?
I have to take inspection, madam.
You cannot keep them hanging just like this. And if they want, and the Mizoram should also think, government of Mizoram should also give a reply as to whether they can accommodate them in the refugee camps.
30,000 of them.
You've got 30,000, I know. So will 17 more will not make any difference.
I'll have to inspect. The Aizol center is over.
Lordship. Lordship, at page 44, Lordship, the Mizoram government had written to the Assam authorities that they are currently providing refugees 30,000 asylum seekers, and in respect of three of them had preferred representation. They have stated that they are ready to accept them. They are ready to take them back in a.
So how many petitioners in this case?
Currently, there are 17, Lordship.
The representation was made by 3.
Made by 3.
At which time we said, okay, then now 17 maybe.
17 is quite huge.
Let them have to instruct.
And you know, since this strife had started in Myanmar, the amount of criminal cases, especially drug cases, that have gone up. Earlier, I remember in 2021, the amount of drugs seized was around 31 crores. As of last year, it was around 83 crores worth of heroin. I do not know whether this is direct connection, whatever. Anyway. Yes, so you take a decision.
We'll take inspection, madam.
Okay, right. Mr.
A. Chakraborty.
A. Chakraborty, learned counsel for the petitioners, submits that the petitioners were arrested in the state of Assam while on their way to Delhi to seek
refugee status.
Refugee status. Full stop. The petitioners, being Myanmarese citizens, had left their country due to the civil war that is going on in Myanmar. Full stop. He submits that the petitioners were convicted and sentenced by the criminal courts in Assam. Full stop. The petitioners, having completed the sentence period, they are now being housed in detention centers in Matia, Assam. Full stop. The petitioners' counsel submits that the petitioners should be relocated in shelters provided by the state of Mizoram for Myanmarese refugees. Full stop. He also submits that applications had been made by 3 of the petitioners to be housed in the state of Mizoram, and which had been agreed to by the state government of Mizoram. Full stop. Mr. N.
M. Setia,
M. Chetia, learned counsel for the
Point number 3, 4, and 5, madam.
That's point number 3, 4, and 5. Shall obtain instructions as to whether the state government of Assam is planning to deport the petitioners back to Myanmar, or or if they have any objection to the prayer of the petitioners to be relocated in the refugee settlements maintained by the state of Mizoram.
The
What's
central government has to take an instruction regarding deportation. Yes.
First up, no, anyway,
Yeah.
we do not know everything. Okay, right, Mr. SK, next para, Mr. SK Roy, the CGC, appearing for the respondent numbers 1 and 2. Submits that. He will obtain instructions as to whether the Union of India has taken any decision for deporting the petitioners back into Myanmar, and as to whether they have any objection to the petitioners being relocated to the refugee settlements established by the state of Mizoram. First up. Refugee, not settlements, refugee camps. Next para. Mr. D. Das, the learned senior counsel, the learned AG for the state of Mizoram. Any object, what you have to take object, whether you are agreeable to them being housed in the state of Mizoram.
So there were two issues for the brief. One is that you have to find a place in Mizoram. We may have no objection, but if your lordship, in respect of the second one, if a deportation takes place, say you want to deport all these petitioners, then of course they have to take it on. We have to find it out where to keep them. That's all.
No, that is, but do you have objection to taking them to the refugee camps in Mizoram? You obtain instructions.
No, we'll take an instruction on.
Submits that. He will obtain instructions as to whether the state of Mizoram is agreeable to house the petitioners in refugee camps maintained by the state of Mizoram, inasmuch as the permission granted by the petitioners, by the state of Mizoram, was with respect to only 3 of the petitioners. Full stop. On the other hand, there are 17 petitioners in this writ petition. Full stop. He also submits that the above permission would be subject to any decision being taken by the Union of India as to whether the petitioners should be deported back into Myanmar. Lists the matter on when? Fixed date. 3 weeks. Give a date.
Initially, when they came, my lord, it was a three petitioner.
That's-
That's why we agreed.
That's what
Now
I
they
said.
came 17.
That's what I said.
It's right.
More the merrier. Give a date. Give 31st May. 31st May? After May, got 31st.
My lord, the Modi Maria on the petitioner side. And 17.
Krishna is a reputed manufacturer of pacemaker.
Huh?
Reputed manufacturer of pacemaker. My lord, here respondent to issue tender notice, my lord. On 21st of February this year. My lord, where your lawsuit will find, my lord, a clause has been given, my lord. At page 34. It
Yes.
should be FDA, USA approval and European conformity certificate of pacemaker. My lord, while India is.
Where?
34, page 34.
Yes.
Top. FDA, USA approval and European conformity certificate of the pacemaker. Whereas, my lord, India is making the Make India program. My lord, now, this tender, my lord, only
I don't know. We don't know. You see, we don't know. These are technical things.
My lord, I'm coming, but to that. My lord, what happened, my lord? We are the only tenderer, my lord, they cancel it.
again tenders issued. But in the meantime, my lord, in 2020, Director of Medical Education issued a tender for pacemaker. And in that, my lord, if you also find the same clause was there. In that tender, my lord, page 67, your losses may see.
Yes,
This is the in the 2020 US FDA approved single chamber pacemaker. So we in the pre-bid meeting, my lord, we submitted my lord reprehensions, and reprehension my lord was considered by the DME. Then they have modified it. It will also come to page 73. Page
yes,
73. This from the bottom, my lord, regarding pacemaker, here also
yes.
single chamber pacemaker with ISO 1348 CE, CMD 13845 certificate and or my lord. So they accepted it, my lord, the petitioner's representation, and petitioner become the lowest, my lord, and he got the supply of that. In the present tender, my lord, first tender was cancelled, then second was also cancelled because they are single bid. Then third tender was issued, my lord, similar with the similarity. We submitted representation, my lord. And pre-bid meeting also, my lord, we have said so, but nothing has been done, my lord.
So page, where is the representation?
Yes, I.
Yeah, but lordship direct, let them consider the representation in the time. Otherwise, my lord, so far as the tender law is concerned, my lord, it's up to the my lord, tendering authority to decide which will be the
Correct.
clause.
Not for us to decide.
My lord, your losses will find page 100, my lord. Page 100. At page, my lord, 101, if your loss will see, my lord. The second para.
Yes,
In your tender, there is a mandatory requirement of US FDA, which is discriminatory restrictive for Indian manufacturer, is also confirmed by Ministry of Health and Family Welfare, Government of India. The relevant circular from the ministry has already been shared with you as annexure in our earlier mail. Would like to inform you that because of the clause, you are unable to participate in your tender as we have regulatory approval from the Government of India only and do not have US government approval. Your tender accepts and mandatorily requires US government approval only. Our simple interest is to modify the US FDA clause as you have the FDA clause so and so as eligibility criteria so that set a level playing field for all manufacturers, both US and as well as Indian. This will also in compliance with the various circulars by Government of India and in accordance with your own DME Assam actions. And that I have shown, my lord. DME Assam has made this relaxation in the last tender, details of which has already been shared with you as your annexure in our heat member. Nothing has been done, my lord.
so let this be decided. You very well know the laws of tender.
Yeah.
So what can we can we say that no, this should be the tender clause?
My lord, no, why I am submitting, my lord, that the director of medical is Assam, my lord, he is the superior authority, my lord. Here the principal medical college has issued the tender now. Now, DME is the highest authority, my lord. DME has made the relaxation. Yeah, both can be there.
Huh?
Both can be there. DME has made the relaxation earlier. And Government of India, my lord, issued
No,
various.
the NIT has been, tender notice has been issued by whom?
By principal, my lord.
By the superintendent,
Medical college, Assam Medical College.
Assam Medical College.
And DME, the higher authority.
So have you written any letter to the superintendent?
Yes, this is a letter, my lord. I have just shown 100, my lord. Earlier also I have written many.
Superintendent where? To this page 100. Page 100.
Yes, yes,
So let this be decided by the, let it be decided.
my lord. Let me decided before this.
Naturally, when is the last date for submission of tender?
The submission already done, my lord.
And have they selected the,
No, that is done. My lord, technical bid has not been, two tenders only there. Just another,
not selected?
not. So let it be decided.
If the technical bid has not been open only, then this can be considered only after the opening of the technical bid. Difficult.
But he cannot participate, no? Why should he participate? He cannot participate then.
We have just
But
got.
in the technical bid only he'll fall. If his technical bid is not as per specification, He cannot submit his tender.
May I have the instruction, let it be on Monday, man. What they are doing.
Hmm.
Because the present status of this man.
Correct, that's what, current status.
2023.
Yes, so there, so it's a two-bid system. Is it a two-bid system?
System, my lord. And the
Technical bid and financial bid.
respond number C is the main, my lord, the Drugs Controller of India. My lord, we have the certificate from him. my lord.
And otherwise also, man, the superintendent, he on his own cannot float a tender without
Correct.
approval of the DM.
No, that is there.
Money will come from the government.
But since he is the authority who has published the tender,
Yes,
it has to be gone to him.
yes, sir. So on Monday, man, let me have the inspection.
My lord, it may be on Wednesday, my lord, in that case, my lord. Because Monday and Tuesday I had some, my lord.
Okay, right. Heard Mr. G. N. Sayawala, learned senior counsel, assisted by Mr.
M. Sahewala.
S.M. Sayawala. M. Sayawala. Who submits that the petitioner is a manufacturer of pacemakers. Who has not been allowed to participate in the tender notice dated 21/2/2023.
My lord, it is a, no, last one is, my lord, dated, I am just giving, my lord. 25, 5/4/2023.
So is this 21/2 also, you are agreed with this 21/2 also? No.
21/2, my lord, because this day one, two tenders were cancelled, then third tender was.
Ajay, which is the third tender?
Third tender is 5/4, my lord. This is
5/4,
5/4/23,
5/4/23, page
page 98, 92,
5/4/92, 5/4,
2023,
5/4/23.
my lord.
On account of
At page 97, that clause is there. Serial number 13.
where? Page number?
97,
Yes, where?
13,
Ah,
clause 13.
13, okay. On account of the respondents requiring the pacemakers to be supplied to be FDA, USA approval and European conformity certificate of the pacemaker. So you put it from FDA inverted and FDA, USA approval and European conformity certificate of the pacemaker closed. The grievance of the petitioner is that the pacemakers manufactured by the petitioner have the regulatory approval of the Indian government only.
Yes.
And does not have the approval of the USA government. As such, the petitioner is unable to participate in the tender process. Though in the earlier tenders issued by the
That's not true.
respondent number
Two.
2, the petitioner had been allowed to participate in the tender process. The learned senior counsel for the petitioner submits that the selection process involves a two-bid system wherein the technical bid is to be opened first up. However, as on date, the technical bid has not been opened by the respondents. Is it?
Well, I'm not sure whether they're open or not, but they have not decided, no information is given to us.
And then maybe you missed the bus.
My lord.
In that case, now let it be tomorrow. I will have the status, my lord, regarding the representation as well as this, my lord, status of the.
However, the two-bid system, huh? Two-bid system, that's all, full stop. Mr. B. Gogoi shall obtain instructions with regard to the status of the selection process in terms of the tender notice dated so and so, okay? When, list the matter?
Tomorrow, my lord. I can have it, my lord, short instruction on that.
Right, tomorrow.
Others tomorrow can be disposed of, my lord, considering,
Tomorrow.
for considering the report.
Yeah, please, your lordship. Lordship, kindly pass over this matter for timing. My senior is legs in court number 6.
Next.
Deeply obliged.
Wait, please, Lord. Well, this is a non-payment of contractual liability matter.
Huh?
Non-payment of contractual liability by the restaurant. by the-
Item number
19, madam, 19.
19.
Madam. A work order was issued to the petitioner, madam. Page 11.
So we issue notice or what?
Well, in earlier occasion, my lord was pleased to dispose of the petition, directing them to verify and if entitled to pay, my lord. In fact, there is a similar order I have annexed with this petition also. And in fact, my lord was also pleased to pass this order, madam, earlier.
No, out here there was the affidavit in opposition. Right, I heard Mr. N.J. Khatania, learned counsel for the petitioner, who submits that the petitioner has not been paid his contractual bill till date. So some issue notice returnable in 4 weeks, Mr.
S. Nyogi, madam.
S. Nyogi, accept notice on behalf of all the respondents. This is the matter after 4 weeks to enable the respondents to file affidavit.
Obliged, Lordship.
20.
Met with the lordship. Sir, it is an application against the order of the order passed by the Assam Board of Revenue, my lord, regarding the mutation, my lord. In this case, what happened? The petitioner is the owner, my lord. That is the annexer A. He is the only daughter of one Jamir Ali. And Jamir Ali originally was the owner of 2 plots of land. Dag number.
Zamin Ali,
Page number 21, my lord.
you see, no, just a minute. Just a minute.
Page number 21, my lord.
No. Daughter of late Afsar Ali.
Afsar Ali.
You said Zamin Ali.
Jamir Ali's son is Afsar Ali. Afsar Ali's daughter is
There is no Zamin Ali, there's a Zamin Sheikh.
Jamir. Actually, Jamir Ali here, my lord, this is same, my lord, same person.
But you please, you are giving a wrong submission. You said the father is Zamin Ali. The father is Afsar Ali, not Zamin Ali.
Father is Afsar Ali, my lord.
That's what. Please, at least because when you say
Jamir
something.
Ali's son is Afsar Ali. Afsar Ali's daughter is the present.
Okay, yes.
There are 2 lakhs, my lord. So, her name was mutated in the year 89 itself, my lord.
Mutated where? Mutated where? Mutated where?
Mutated over this plot of land, my lord.
Over the plot of land, where in the over the plot? In the records, you mean?
Yes,
In the land records.
record of right. Then, my lord, she is the only daughter, my lord. So, she is the owner. The total land is more than 3 bighas to 11 acres. Now, my lord, thereafter she filed 4 applications for partition of the land. Then during the partition of the land, my lord, there is a compromise that somebody, they claim to be our relative, but we do not admit that, my lord.
Are there a party here? Are those
Yes,
relatives?
all the respondents, my lord.
They
They claim to be the relative.
So
of
there
the-
is a dispute between, the dispute for
Yes,
the
yes,
property.
yes.
Huh.
Then there was a compromise, my lord, with regard to possession. And an agreement was entered into by the parties, my lord. And on the basis of this, my lord, the respondents, my lord, they filed a mutation case.
They filed a
Mutation.
For mutation of the land,
Yes.
as per the compromise.
Yes, madam. Over this 19 lessons of land. Then we objected that they are not our.
Then
relative.
that is not a compromise then.
Compromise only with regard to possession, my lord, not with regard to title.
Okay.
Then, my lord, the circle officer allowed. And against that
Allowed the mutation of the land
mutation of the land in their name, my lord,
in the name.
and deleting my name. Well, that is the problem here. Then, my lord, we preferred an appeal before the learned additional deputy commissioner, my lord. And additional deputy commissioner passed this order. Your lordship may be pleased to see page number 29.
Yes.
First para, my lord. It is not known how and on what basis the circle officer Romia Revenue Circle had granted mutation only on the basis of a registered mutual settlement deed without there being any registered sale deed or gift deed.
Then
Mutation order was set aside, my lord. Then they preferred an appeal before the Assam Board of Revenue. And Assam Board of Revenue, my lord, your lordship may be pleased to see page 34, my lord. Last.
yes.
line. Therefore, this agreement is an acceptable instrument for proving succession of the appellant to the disputed land for the purpose of mutation in the records of right. In view of this, the court finds that the appellants are entitled to have their name mutated. Next page, my lord. The record of rights as they are meeting the twin criteria for mutation, that is possession and succession. How possession is there, my lord. Possession is there is an agreement between the parties, my lord. But how succession will come? That is my grievance, my lord.
Where is this
Revenue board
mutual settlement deed? Where is the settlement deed?
settlement deed is, my lord, actually in my copy, my lord, it is invisible, so I cannot file here. It
That is the
before
basis.
it
That is
before
the basis
before
for,
the record of appellate court, my lord, in the Assam Board of Revenue.
you see, Mr. Counsel, that settlement deed is the basis for the entire issue that is being raised here.
Assam Board of Revenue also, my lord, admitted that with regard to possession only. But
Yeah,
they
no,
hold
no,
that the agreement.
we have to see what is there in the settlement deed, what has been written there.
Then, my lord, actually. in
Yes,
So in the judgment passed by the revenue board, page 34.
yes.
The last part of the page 34, if we just begin from there.
Yes.
So we can make out that sufficient material has been found as regard that family settlement whereby the court has come to a satisfying conclusion.
Where are you reading? Page 30?
Page 33, last part.
33.
In this context, it has been cited, the Honorable Supreme Court judgment so and so, so and so, so on. Appellant argument is that the agreement dated 29/4/1992 fulfills all the requirements of a family settlement. It also clearly says that the land under dispute is a property inherited by both sides from the ancestors. Therefore, the agreement deed is sufficient to get his name mutated in the land record.
That is what that settlement deed has to be part of this.
Ultimately, the record has to speak, so we need to record what exactly the settlement deed has been.
We'll call for the record. We'll issue notice that one. No say. What? Or we can only say that status quo. So that the property is not sold.
They are in possession, my lord. Let there be set up, my lord.
Petitioner would know better because who is in possession, that matters.
They are in possession, my lord.
Who is in possession?
They are in possession.
Okay, they are in possession.
Let there be status.
But okay, we can say that status quo as a date, so that they don't sell the property.
Yes.
Heard Mr. PKPR Kalita, PK Kalita, learned counsel for the senior counsel for the petitioner. Who submits that the petitioner had inherited plot of land measuring 19 lechas covered by dark number 886 KP Pata number 122, situated at village Rangia town, Muza Panduri in the district of Kamrup, Assam. The petitioner's case is that due to a dispute between the petitioner and the private respondents, comma, a settlement deed had been made between the parties wherein the in the settlement deed, what was stated in the settlement deed?
Regarding possession, my lord, possession. Regarding settlement was.
Wherein a compromise on the possession of the land
Yes.
had been made.
Yes.
And no compromise on the title to the land
Yes, yes.
was made between the parties. Full stop. He submits that despite the above, the circle officer had mutated the name of the
Respondent.
respondents, private respondents. How many respondents are there?
Yes, my lord, there's a five.
Private respondents in the record of rights of the land. Full stop. The petitioner being aggrieved filed an appeal before the deputy commissioner
Additional deputy.
and by order dated 10/9/2019. And by order dated 10/9/2019. The additional deputy commissioner Kamrup set aside the mutation of the names of the private respondents in the record of rights. First up, being aggrieved, the private respondents preferred case number 57 RA bracket K/2019 before the Assam Board of Revenue, Guwahati. Case number 57 RA bracket K/2019 was allowed by judgment dated 8/9/22, which set aside the order dated 10/9/19 passed by the learned court of the additional deputy commissioner Kamrup in case number 13/2016-70. The petitioner being agreed by the same has approached this court. Issue notice returnable in 4 weeks. Who accept notice?
1, 2.
Mr. S. Sharma, no.
S. Bolwa.
S. Barwa accept notice on behalf of
3 and 4.
3 and 4. While Ms. G. Hazarika accept notice on behalf of response number 1 and 2. Petitioner takes steps for service of notice upon the respondents number 4 to 12. 5 to 12.
5.
By registered post with AD within a week.
3 days. my lord.
Within 3 days. Within 3 days. Then what about the records
Record will be necessary.
from the
Assam Board of Revenue.
registry to call for the records of the case from the Assam Board of Revenue, Guwahati? This is the matter after 4 weeks. Before that you say, in the interim, status quo as on date should be maintained by the parties. Interim order and this is the matter after 4 weeks.
My lord, as per the provisions of Assam Tea Plantation Provident Fund Act, my lord, if a tea garden falls default in payment of the Provident Fund dues, my lord, the authorities have the power to attach the garden and thereafter put it to sale under auction, my lord. The issue involved in this case is, my lord, regarding the auction sale. My lord, what has happened, if your lordship takes up page 29, my lord.
I'm here to receive the instruction, my lord. Let the matter be taken up on Monday, my lord. On the day, your lordship will be able to finally dispose of the matter, my lord.
petitioner's bid was cancelled. Correct.
Cancel.
You were the successful bidder.
I am the successful bidder, but the ground which they have taken is that one of our directors went into a personal arrangement with the authorities for taking over the management and to facilitate the recovery of the PF dues, and which was not successful. Now, my lord, keeping that arena open, that whether his director going into an arrangement in his personal capacity will bound the my lord company, who is the petitioner before your lordship, whether his actions will have any bearing on that. I have taken it on bidding.
Okay, anyway, heard Mr.
I am G Rahul, my lord.
G.
Rahul.
G. Rahul, learned counsel for the petitioner, who submits that the petitioner's bid in the auction of the Fateh Mabad Tea Garden was accepted. However, his bid was cancelled by the respondents in view of the
Clause 14 of the tender notice.
in view of clause 14
my lord.
of the tender notice dated
9. It's page 29. Tender notice dated, my lord. 6/12/2020.
Huh?
6/12/2022.
6/12/2022. Gustav. Mr.
NC dash, my lord.
NC Das, learned
Response number 2 and 3, my lord.
senior counsel for the response number 2 and 3 submits that he will obtain instructions with regard to the same. List the matter on
Monday, my lord, because Friday,
Monday.
holiday, my lord.
Monday. Wednesday? Is it okay? Wednesday.
Obliged.
May I please your lordship? My lord, this petitioner is a person with disability. He is 100% visually impaired, lordship. He has applied for the Aadhaar card and which is not being issued to him. And for this reason, he is facing difficulty is that the ration, because they belong to the marginalized section of the society, his family.
Yes, who is appearing for the other side?
Sir, I am preparing for respondent number 1, 3, and 4, ma'am. CGC, ma'am.
1, 3, and 4. Yes, CGC. Who is to give the other card? Who is to do that?
Yeah, is respondent number, lordship. UAID is a respondent 3, lordship. And regional office.
You are appearing
specialist
for 3 and 4.
1, 3, and 5.
Then you obtain
4.
instructions. Why is the petitioner not being given other card?
Yes.
And his ration is stopped.
Will give short date. When can you give a thing?
Not possible, my lord.
Huh?
I have to take instruction from government of India.
So
Delhi, from Delhi.
No, regional.
what is there? I say respond number 4. You take
Yes,
instructions from respond number 4. Miss
D Ghosh, lordship.
D. Ghosh, learned counsel for the petitioner, submits that the petitioner is a physically handicapped person suffering from permanent blindness. So the petitioner's grievance is that he has been denied Aadhaar card without any reasons being provided for the same. And the petitioner is facing difficulties as he is not being given ration in the absence of any Aadhaar card. Gustav. Mr.
Yes, Bhattacharya.
P.S. Bhattacharya appearing for CGC.
Yes, madam.
CGC appearing for the respondents number
1, 3, and 4.
1, 3, and 4. Submits that he will obtain instructions from the respondent number 4 by the next date as to why the petitioner is being denied Aadhaar card. Who is for 2 and 5? State of Assam, Commissioner Secretary, Assam Food Civil Supplies. Mr. S. Barwa, accept notice on behalf of respondents number 1 and for Registrar, General Administration Department?
2 and 5.
Huh?
2 and
2
5.
and 5. But who is Registrar, General Administration
There is
Department?
nothing.
There is no registrar.
There is no registration.
General administration department.
Mr. Council, yeah, madam, in any department,
Apologize for this wrong.
you
this-
corrected,
Yes,
you
Lordship.
corrected, you say secretary to the government of Assam,
Yes,
okay? Instead of registrar, you can.
yes, Lordship.
Accept notice on your response number 2 and 5. Petitioner is allowed to make correction to the cost title in respect of the respondent number 5 by hand during the course of the day.
State may be reflect,
Huh?
cause list may reflect
Cause list to reflect
state government.
counsel for the state government. List the matter after. List the matter on give a date. When? 3 weeks.
Lordship, meanwhile, his ration may be provided to his,
How?
because,
Uh,
then next. week
Wait,
they
let
can-
us see.
Next week, because there is a judgment of Uttarakhand High Court, where in this sort of matters, and even the law says that they have to take special care for persons with disability. Section 5 of the Aadhaar Act says that, Lordship.
Let him give us one thing. We'll tell him to give you back rations.
If that is provided, because people will.
Then how will you eat so much?
Because at least these are the poor people, they are, and only bread earner of the family is. the
How
mother.
old is he?
He's 19 years, he is studying,
19 years.
yes, he is studying in Montfort School, special school, Lordship. And mother is only the
Huh?
sole bread earner of the family.
29 size.
Deeply.
May I please, your lordship? My lord, here, the petitioner is agreed by the imperial order, that is annexure 3, page number 17. Here, my lord, the circle officer blessing for the revenue circle pass the imperial order. Whereby, my lord, the name of the petitioner was deleted as a partner from the record. And the entire line was mutated in the name of the private respondent number 5, my lord. Here, my lord, the respondent number 5 and petitioner are the brother and sister, my lord.
Brother and sister.
Brother and sister. There are total 5 brothers and sisters. So after the death of the father, land was devolved upon the brother and sister by way of inheritance.
So who is to do this?
Ultimately, my lord,
Why should we decide this issue?
my lord, actually my grievance is that while the name was deleted, the order was passed, the imperial order was passed, no notice was served.
Huh?
No prior notice was given to the petitioner, my lord. At least the notice ought to have been served to the petitioner to show cause or to submit opposition, or at least to show cause, my lord. That was not done. Ultimately, it is a violation of the principle of national justice, my lord. And secondly, my lord, against that order, my lord, I also filed one application before the deputy commissioner. That is page number 20, my lord. That application was filed in 2022, my lord, 6th of May 2022, almost 1 year. That application is pending, my lord, disposal.
Application for what?
For, my lord, challenging the order of the circle officer
Before whom?
before the deputy commissioner. So that could have been treated as appeal, my lord, against the order of the circle officer, but that was not done. And still, my lord, my application is pending, my lord.
You
So
filed a fresh appeal.
So, my lord, my grievance is that, my lord, a direction may be issued to the respondent to dispose of my representation, my lord.
You file a fresh appeal. There, when you file an appeal,
Well, already filed, my lord. That is page number 20, that is the appeal. Appeal means the
page number 20.
20, my lord. No, to the deputy commissioner. Against the
And
order of the
when was the mutation done?
mutation was done, my lord, on 16th of December 20. And, my lord,
2020.
20, my lord. Only 20, 20, my lord.
20. And you filed your appeal after 1.5 years.
Because, my lord, it came to my notice after, my lord,
Is it within time? Was it, is there any, is it hit by limitation or something?
no, my lord, there is a limitation, but the deputy commissioner at least could have, my lord, decided that matter, and at least if the deputy commissioner rejected my application on the ground that it was barred by limitation.
Yes, Mr. What to do?
This is not the right way of filing an appeal there as per the relevant
It's
provision.
a complaint.
This is a complaint, this is a representation, any name can be added to it. So let him file a fresh appeal,
Let him file a appeal. And with the condemnation of delay,
if at all that.
if required. Is there any appeal period?
My lord, there is a appeal period, my lord, as per section 147 of the appeal ought to have been filed, my lord. For us only this. Well, 2 months, my lord.
2 months.
2 months.
When you file an application with condonation, why should we take up this matter?
Some observation may be made accordingly, my lord.
What observation?
At least, my lord.
That you have come to this court late.
No, my lord, because even my representation that was made in 2022, 6th of May.
You go there with your application. Heard Mr.
MA Islam.
M.A. Islam, learned counsel for the petitioner, who submits that the petitioner and the respondent number 5 are co-patadars of a plot of land which was inherited by them from the deceased father. However, there is nothing out here. What land, what pata number, nothing is here.
My lord,
Dark number, nothing is here.
well, there are two, my lord. There are two of my petition. My lord, the entire, my lord, details has been given, my lord.
Okay, okay. Are the co-patadars of co-patadars of plot of land measuring 2 bighas, 1 katha, 12 lechas, covered by dark number 45 of KP Pata number 47, situated at Revenue Village, Bamunpara, Part 2, bracket town, under Muza and Revenue Circle, Bilasipara, Dhubri district, Assam. The said land was inherited by them from their deceased father. However, the respondent number 5 illegally mutated the entire land in his name by forging some documents by the impugned order dated 16/12/2020, issued by the circle officer, Bilasipara Revenue Circle. The petitioner's counsel submits that the petitioner made a representation dated 6/5/22 to the Deputy Commissioner for correction of the record of rights. However, the petitioner's representation has not been disposed of till date by the authorities. He accordingly prays that a direction should be issued to the respondent number 2 to dispose of the petitioner's representation dated 6/5/22. Mr. S. Barwa, the learned counsel for the respondent numbers 2 and 3. No. No.
Number.
Yeah, numbering is wrong.
Numbering. It should be 2 and 3.
You correct this numbering. 2 and 3. Appearing for respondent number 2 and 3. And Miss G. Hazarika, appearing for the respondent number 1. Submit that as the petitioner has an alternative remedy by way of filing an appeal under
Section 147.
Under section 147
Of the Assam Land Revenue
of the Assam Land Revenue Regulation
1886.
1886, the petitioner should avail of the same. On considering the fact that there's an alternative remedy, statutory alternative remedy available to the petitioner, this court is not inclined to entertain the present writ petition any longer. The writ petition is accordingly dismissed, with liberty being given to the petitioner to approach the appellate authority in terms of along with any application for condonation of delay that may be required in filing the appeal. The writ petition is accordingly disposed of.
All right.
Well, in 1961, the father of the petitioner was allotted a land measuring 4 bigha 10 lachas.
The petitioner's father.
And his name was after payment of premium, page 22, my lord, you'll also find His name was recorded in the Chitha. Draft Chitha.
In the draft chitha,
Draft Chitha. And
not the final chitha.
no,
There's no final
no, no,
chitha.
now, my lord, after the death of the father, my lord, the petitioner applied for mutation. Nothing was done. We approached this non-court and this non-court again directed, my lord, to consider the same. But in the meantime, my lord, we filed the application. We discovered, my lord, the land of the, which was stood the name of the father petitioner with the patta name. The patta has been deleted and that was made government land, my lord, Sarkari land in respect to 5 tax. That I have annexed.
Where?
My lord, that it starts, my lord, at page 57 onwards, my lord. 5 tax, my lord. My name is not there, patta name, patta is also my deleted. Patta. Without any notice, my lord.
So to issue notice, that's all.
Notice, my lord, at this stage, my lord, let them file an affidavit, my lord, some, that may.
Yes, what is to be done? You obtain instructions or what?
No, no.
Huh?
We may have inspection in the.
Yes. Heard Mr. G. N. Sayawala, learned senior counsel for the petitioner. Assisted by Mr. M. Sayawala. The petitioner's case is that the petitioner's father was granted allotment / settlement of a plot of land measuring 4 bighas, 10 lechas covered by DAG number 1071 bracket 0 old /280 bracket N of Pata number 290 of Revenue Village Betkuchi under Muza Beltola Guwahati in Kamrup district, in Kamrup M district, Assam. White order dated 18/10/1961, issued by the Assistant Settlement Officer Kamrup. The petitioner's case is that the petitioner paid the premium amount required to the government of Assam. Petitioner's father. Petitioner's father paid the required premium amount to the government of Assam, and thereafter the name of the father of the petitioner was duly incorporated in the draft chitha of the for the aforesaid plot of land. The first up, after the death of the petitioner's father, the said land has been occupied and possessed by the petitioner and his family members. The petitioner's counsel submits that to the surprise of the petitioner, the petitioner's counsel submits that on inquiry, the petitioner was surprised to learn that the record of rights for the aforesaid plot of land had not been corrected by the respondent authorities. That is, the name of the petitioner's father had not been incorporated in the draft chitha. Though the premium had been paid way back in 1961.
Draft chitha was there, madam. Draft chitha was there, madam.
Huh?
Draft chitha, his father's name was recorded.
Father's name?
Yes. That page 22. Draft chitha, father's name was recorded. Page 22. Petitioner's father's name was recorded. But subsequently.
But records are different. Chitha will be different, no?
No, this is the main source is chitha. Thereafter, Jamabandi is issued, my lord. So subsequently, my lord,
so they could not find the chitha according to you, or what?
No, my lord, original chitha was found, but subsequently it was converted to Sarkari land.
The chitha is found.
Yes.
The chitha is there.
Chitha is there, original chitha is there. Well, draft chitha is there.
Where is that in your petition?
This page 22, my lord. That I have annexed, my lord. Page 22. You see that? His name is there, my lord, Ramakanta Sharma. His name was recorded. I have got a certified copy also, my lord, at page 23 in.
So what have I said thereafter?
The petitioner's counsel submits that on an inquiry, the petitioner was surprised to learn that the record of
Says that
rights.
the records of rights of the plot of land does not you have said, please read to your synopsis at the page 2.
My lord.
Please read the second paragraph. However, to the utter surprise and dismay of the petitioner, that is at line number 9.
Yes, yes. Other petitioner was inquiring about the status of land came to under records of the aforesaid problem corrected by the respondent authority.
Had not been corrected by the
My lord,
respondent authorities. So what record?
Draft chita it was made. But other my lord, regular chita it has not been made.
That's what I was saying to you earlier. So there is actually a final chita to be made.
My lord.
This is a draft. This is not the regular chita. That's what. So what have I said?
The petitioner's counsel submits that on inquiry, the petitioner was surprised to learn that the record of rights for the aforesaid plot of land had not been corrected by the respondent authorities. That is the name of.
In as much as. That is Yukata. In as much as. Though the petitioner's father's name had been incorporated in the draft chita, the petitioner's father's name was not recorded in the final chita. Final/regular chita. Though the petitioner has applied for mutation of his name in respect of the aforesaid plot of land, by correcting the revenue records, the respondent authorities have not taken any steps for correction of the records. He further submits that the petitioner has now come to learn that the plot of land, that the aforesaid plot of land has been divided into 5
Like
darks.
that's.
5 darks.
And med surgery.
Huh?
And med surgery.
And
Med surgery, government.
Sarkari land
Surgery.
and made into government land. Issue notice returnable in 4 weeks. Mr. S. Barwa accept notice on behalf of
3456.
3456.
For 1, 2, and 3,
Name
MSPR Mohan.
3 Nohai.
Yes, 1, 2, and 3 CFPs and the rest 5.
1, 2, and 3. Therefore, and here for 4, 5, and 6. This is the matter after 4 weeks to enable the respondent's counsel to obtain instruction and file affidavit in missing.
25. Please, Your Lordship. Lordship, in this matter, we have filed our affidavit during the course of the case.
Filed an application for vacating the interim order caused by this honorable court, whereby the extension order given to the respondent, private respondent was stayed. What I pray, my lord, let the fishery, because the extension power is under rule 8B of the fishery rules. After getting some reports and all, they can consider petitioner's applications when they grant extension. So the whole matter can be disposed of if they produce the record, fishery department record. Next week, because otherwise it will become influx, so there is a stay order and there was an extension order by an order dated 29/12/20.
You have filed your written objection today. Written objection in the IA.
Affidavit in the IA.
Affidavit in opposition
Yes.
in the IA. And what about you? You can bring the records.
Yes, my lord, we have not received, we have received instruction, my lord, after my lord, suspension of the earlier my lord, order, my lord. The process has been reinitiated for settlement of the PCI, my lord.
So that will be dangerous.
My instruction, my lord.
That will be
Dangerous because my settlement, my extension order has been given in favor of the private respondent.
There-
And
there has been
In these
suspended, my lord.
circumstances, if they again issue the process, it will become futile, my whole thing.
you bring the records.
Yes, my lord.
They should provide the records relating to the order of extension. Next week, the matter can be.
Next
disposed
week,
of.
to extend,
Any date, your lordship.
Lordship may fix it on 22nd.
Mr.
R. Chauhan,
R. Chauhan appearing for the
opposite party number 1.
OOP number 1 submits that affidavit in opposition has been filed in the IA today.
Yes.
Mr. M. Chetia,
Yes.
learned counsel for the fisheries,
No, it's the government. My lord.
for the state government, submits that he will produce the records with regard to the extension of the settlement. Is it
Extension.
extension of the settlement?
Extension
the
of
next
the
day.
fisherman.
Extension of the
Of the
fishery,
fishery.
settlement of the fishery
My lord.
by the next day. List the matter on 22nd.
Lordship interim to continue.
Interim order to continue till the next day.
Well, they should not, in the meantime, give NIT and all. That will be, that will.
Already, my lord,
Status quo.
process has been initiated for my lord, resettlement of the fishery, my lord, because
For
These-
that matter, there is some civil suit is going on. But in the meantime, till 22nd status quo.
on the gap of the civil suit, my lord, they got that instruction.
Uh-huh.
Extension.
Let us see. 22nd is,
Till 22nd, they should not do it. Otherwise, it will become the extension order given by the authorities only.
extension order given to them.
Here, no, given to us by the authority.
Extension order given till,
For 2 years,
till,
till 24. It was given
They
on
have
29,
obtained
12,
their-
22.
huh?
They have obtained their extension order on the gap of their civil suit, my lord. And
Ah.
subsequently, that civil suit has also been withdrawn, my lord. After getting their extension order.
Let us see.
Yes, ma'am.
On the status quo till 22nd, if it is not given, they give the settlement to somebody else.
No, once the status quo is given, so we'll list it next week then.
No, next week.
Next week.
They have to produce the record, my lord, how they have given extension.
On 22nd, my lord. We'll put it there.
Today is what? Today is
Fourth.
fourth.
No,
Third.
third.
22nd is pretty far off.
Yes. They have to produce records only, nothing else, my lord.
This is the matter on 15.
My lord.
15.
15.
For attempt for disposal, because on the basis of the
Yeah.
record, your lordship. is-
15.
My lord, in this matter, in terms of the last order, my lord, I pray for some more time to take instruction, my lord. 10 days time, we will get
10
instruction.
days is too
Once
long, lordship.
Settlement is going on, my lord. We have already communicated to the authorities.
Said,
But
I have
10
not
days-
received any instruction.
I sure, my lord, I am in talks with the authorities.
I don't know, madam. One side is saying that settlement is going on.
There is no settlement going on. I am trying desperately for a settlement. If lordship looks at the last order, lordship will see what is my state.
Let me give one last chance, my lord, 10
So
days.
to say settlement is going on is wholly incorrect.
You see, Mr. RKD Chaudhary had said that there is no response in spite of his communication.
My lord,
So where is
I have
the
taken
settlement?
instruction, but I am appearing on behalf of Arkady Chaudhary. He's in this post today. I'm having a severe back pain, my lord, so.
So let
10
it come
days.
up on Monday, lordship.
No, not so fast. We have got so many cases there. This is not the only case that is there.
From 2014 or something.
Huh?
2014, I'm languishing.
No, there's 115 and there's 120.
Yes, lordship, but matter carries on from 15. 20 we have to file for another.
I don't we give 10 days time. I will, I ensure, my lord, I'll-
Wednesday next, lordship. I think that's 8 days. Little bit of compromise.
all right.
Hmm?
10 days. 10 days, 10 days, my lord, we give.
Huh?
Minimum 10 days time, lord, we.
Mr.
H Gupta, my lord.
Huh?
H Gupta,
H. Gupta, CGC.
my lord.
Submit that. Some instructions are necessary for settling the matter with the petitioner. Accordingly, prays for 10 days time. List the matter on, give a date. 16/5.
That's
You
more than-
wanted 15/5, 16/5.
It's almost 15 days or almost 2 weeks.
No.
16/5, right?
Hmm.
Today's the 3rd. So almost 2 weeks.
I will get it, my lord.
That's okay.
Obliged.
May I please your lordship?
May I please, your lordship?
Yes.
Petitioner is the registered association of NFLWA OBC employees, lordship. Now, lordship, the railways have granted them certain facilities. They are enjoying it since 1999. And lordship, the last list of elected office bearers is 6/8/2019. That is page 79 of the writ petition. Now, lordship, they have issued an impugn order, which is at page 94, 22/10/2020, by which they seek to withdraw the facilities and seek to withdraw our list of elected office bearers. Against that, we had approached this honorable court on the ground that, on the plea that, lordship, railways, neither railway nor register of society, they do not have any power to enter into our internal aspects, lordship. That power is only vested in the civil court. Now, lordship, the matter was last listed on 22/6/2022, lordship. Thereafter, lordship, there have been certain developments. And otherwise, we are protected by this honorable court. Our facilities, there is a status quo order with regard to the facilities, lordship. Now, last matter was last listed on 22/6/22. Thereafter, the matter is listed today, lordship. Now, lordship, in the meantime, there have been certain developments. The last list of elected office bearers, 6/8/2019. 6/8/2019, that expire, it has a tenure of 2 years. I have all the documents, lordship. Now I'm just making submission. 6/8/2019, 2 years was expired on 5/8/2021. 21. Before that, they conducted.
2 years already over, my lord.
Let me complete, lordship. Let me complete. Before that, status quo order is operating. So we are holding the office. Facilities are given to the employees. Now, lordship, 2 years was over. Before that, they conducted election, and fresh list of elected office bearers are elected. Now, lordship, this according to the procedure, a detailed procedure is there, how the list is to be submitted to the general manager, and general manager, NF Railway, has to circulate that list. Now, our new list of elected office bearers is pending with the general manager for circulation. He is not circulating because of pending litigation, perhaps, I do not know, lordship. So for that, lordship, we had preferred another writ petition. That is writ petition number 3601/22. That was, in that matter, notice was issued, and thereafter it was not listed. So that is the position. So now my humble submission would be, lordship, court matters can be listed on a particular day, and the entire matter can be disposed of, lordship.
So for this present committee is concerned, their tenure is over, and pursuant to the interim order passed by this. Your tenure is over in more than 3 years now, in 8/6/2019. In 2019 it was over.
No, 19.
And 8/6/2021 over, up to 5/6/2021, their term is over. And 21. Yes, 21.
I'll clarify.
And now, pursuant to the interim order, they are the beneficiary. Now, another committee has been formed. That committee, they have no suppressed that. That committee, they have no challenge. Neither before the honorable court, nor before the civil court. As per their own procedure, they have to approach before the civil court, which is because this is a dispute between two groups, them and the newly formed body, newly formed body formed 24 January 2021. And
then that will also expire.
No, not explain.
But
First of all, you have to be a living body as on date. Yeah, your term expired in 21. You're finished.
The body is there, lordship. It is regarding our list of elected office.
The list of elected office bearers.
Office cannot remain vacant, lordship. So the next list is pending with the general manager.
That is another one.
That is the only list. With regard to that, I have sought RTI reply also. It is there with me right now, lordship. And that is the only list pending with the general manager for circulation. So, and regarding that circulation, the second writ petition has been filed.
Unauthorously, they are using the space, otherwise they are not entitled for their tenure. They have,
If this writ petition is disposed of today, lordship, then the office will become vacant. And if the office becomes vacant, then, lordship, the OBC employees will suffer, lordship, because they are extended certain facilities.
Already another committee. We'll tag that other case and dispose it of. The problem is that,
Any day, lordship.
of his reputation, kindly for a moment,
Maybe next week, Tuesday.
Just a minute. Kindly see, this is his statement, Para 10, second line, last fourth line. tenure of the said elected
Huh?
list of newly elected zonal executive committee. My lord, this is the petitioner for the year 2019-2021 is 2 years from the date of taking over church. My lord, they have taken over the 8/6/2019, my lord. They were suspended, my lord, later on 12/8/2020. Now, my lord, since the interim order is there, my lord, interim order of this interim is report 23/2/2021, my lord. Interim order 23/2/2021.
I have already made this submission status quo where we
My lord, more than their tenure, my lord. More than 1 year they person to the
So
interim order.
you
they
are,
have-
you are not an office bearer anymore.
Yes, and no, not my lord. You're correct, my lord. So that's the problem, my lord.
Till the next.
Where are the next list of office bearers? Where they are situated? Where they are
My
located?
lord, we could not accommodate due to the stay order, my lord. Therefore, we have filed one vacation application.
Okay, so
We
they
have
are not
taken
leaving.
time.
This same general.
My lord, the new
General
form.
secretary is the newly elected general secretary. So their list is also pending with the, general manager for circulation. So general manager is not circulating. So if, for that I have filed the second writ petition. If second writ petition is then both can be decided together. Otherwise, the office will
This is
vacate today
impossible.
itself, lordship, and
Let's
suffer.
tag it together. We'll
My
decide.
lord, lordship may be pleased to fix it. there.
Maybe next,
Because in the
Okay,
other
we'll fix
matter, I
it.
am not there.
We'll see, we'll fix it.
Yes, my lord.
Right.
maybe next,
List this matter along with WPC number 3601/2022
22,
as per the request made by Mr.
GJ Sharma.
GJ Sharma, learned counsel for the petitioner as petitioners. List the matter on.
My lord, one submission may be recorded, my lord. I humbly pray, my lord. My lord, they form on 8/6/2019 and their term is already over.
What's up?
That's
Acha. Before I say this, say Mr.
BK Das, my lord.
BK Das, learned
Correspondence.
counsel for the
Respondents railway, my lord.
respondent railway submits that as per
Para 10 of
the-
the repetition.
as per para 10
Yes.
of the writ petition, the list of office bearers have been elected for a term of 2 years
With effect from 6/8/2019.
with effect from 6/8/2019. So as such, their term has expired on 5/8/2021.
My lord.
And that's all. List the matter on, give a date after 1 week. Or next week,
Next.
Thursday. Have we fixed any item, any cases, 11/5?
Maybe on 12th. It's not. Okay then. Interim till
11 is a Thursday, no?
Thursday.
Have we fixed some cases? I don't know.
In that case, my lord, one day prior to that, my lord, no problem, my lord.
No, when, okay,
Can be on
11, my lord. it will be
11,
Thursday.
is the matter 11.
Yes. Obligation.
interim may continue till then. Sir.
Interim
There is
order
a
to
problem,
continue
my lord.
till the next day.
Till that. Obligation.
May I please, my lord? May I please, my lord? My lord, in this case, I am appearing for respondent number 4, my lord. My lord, I pray for 3 weeks time to file my affidavit, my lord.
I am for respondent number 2 also. Similar price also. 2 weeks time may be granted also.
Have you taken steps?
Yes, my lord.
Huh?
Respondent number 5, my lord.
When did you take steps?
My lord, on the last occasion, my lord, respondent number 5 was I actually PNRD, my lord.
Huh?
And in PNRD, my lord, inadvertently, in the initial order, it was observed that the steps has to be taken on respondent number 4 and 5 to register post. Thereafter, it was pointed out, my lord, on last occasion. And accordingly, his name has been shown, my lord. PNRD.
5 has been represented by my learned friend.
Yes, for 5.
PNR.
Oh, very good. Okay, Mr.
AK Gupta for respondent number 4.
AK Gupta for respondent number 4, Mr.
And Hassan also.
N. Hassan for respondent number 2, and Miss for respondent number 5. Are granted
3 weeks time, my lord.
3 weeks time to file affidavit in opposition.
Yes, madam, you are there also. Miss P.R. Monta, appears for point number 1. You are filing any affidavit? No.
Already interim them.
Is the matter after 2 weeks, 3 weeks. Interim order to continue till the next week.
Problem. Affidavit. Affidavit. Well, admitted amount matter, my lord.
Well, I request some time for filing the affidavit.
Okay. Mr. B.K. Das, learned counsel for the railways, is granted
3 weeks, ma'am.
3 weeks time to file affidavit in position. What is the matter of the 3 weeks?
It date may be fixed, my lord. Small cooperative society.
Next,
Next.
next.
May I please? My lord, this is also admitted amount matter for higher charges of a vehicle, my lord, in the district of Hailakandi. My lord, may see the affidavit of the government, my lord,
4 to 8.
my lord, at page 36, my lord.
With regard to sumo vehicle, they have said that they have paid everything.
My lord, the 184,058, which has been admitted by them in the affidavit. My lord, page 36, last line,
Page 36, last line.
and remaining rupees 184. My lord, got it? 36 of the affidavit.
Ah,
Paragraph 12, lordship, last 2 line, lordship.
so 184 is still to be paid.
My lord,
So that's all. You pay that amount. And with regard to any, and with regard to the unadmitted amount, what to do?
no, my lord, they have paid.
Paid.
It was 12 lakhs something, my lord. 10
So
lakhs
only
they have
this,
paid.
so this para 12 covers everything.
My lord,
Lordship may put the paragraph 12 and dispose of them.
Yes, yes.
my lord, the time limit may be fixed. My lord.
Heard Mr. M. Sayawala, learned counsel for the petitioner, as well as Mr. K. Uvoy, appearing for the respondents. The petitioner's case is that his Tata Sumo vehicle bearing registration number
AH24, seeing the synopsis. My lord.
you take it from here, huh?
Right.
Order dated 8/12/2021, second paragraph. Okay. So, next paragraph. Mr. K. Roy, learned counsel for the respondent submits that in terms of para 10 of the affidavit in a position filed by the respondent number 4,
What is paragraph 12?
paragraph 12, sorry, paragraph 12, the outstanding liability payable to the petitioner for hiring of his vehicles amounts to rupees 1,84,058. And the same will be paid at the earliest. Full stop.
My time limit may be
Full
fixed.
stop. Next para. I have heard the learned counsels for the parties. Next para. Para 12 of the affidavit in opposition filed by the respondent number 2 clearly states that the respondents are still to pay an amount of rupees 1,84,058 to the petitioner for hiring charges of his vehicles. Full stop. As the liability of the respondents towards the petitioner is clearly spelled out in para 12 of the affidavit in opposition filed by the respondent number 12. The respondent, which respondent is to pay? Number 4 or what?
Then may direct the respondent number lordship 3 and 4.
3 and 4.
The respondents number 3 and 4 are directed to pay the outstanding liability of rupees 184,058 to the petitioner within a period of 1 month
Lordship,
from the date of receipt of a certified
be
copy of this
lordship.
order. Huh?
2 months, lordship.
Huh?
2 months, lordship.
Huh?
2 months.
2 months, 2 months.
DPL.
Today, morning, the private respondent number 5 has filed the affidavit in the position. I need to file my response. Lord.
You have to file reply.
Yes, sir.
Yes,
Can it be fixed on?
Huh?
I'm appearing for respondent number 5.
We have filed today the affidavit now.
Verified today, okay. Mr. R. Dhar, learned counsel for the petitioner, submits that affidavit in opposition has been filed by the respondent number 5 today. And accordingly, he needs,
To file my response.
how much time?
On 23rd May, Lordship will fix it. Lordship will fix it on 23rd of May.
And he needs 2 weeks' time to file affidavit in reply. This is the matter, give a date. Anytime,
23rd.
anytime after 3-4 weeks, whatever.
Oblige.
Matter related to non-payment of vehicle.
Hiring charges. Yes,
Lordship may give another chance, we have yet to obtain.
Mr. K. Gogoi, learned counsel for the respondent, is granted how much time?
At least 2 weeks, minimum.
Granted
2 weeks time.
2 weeks' time to
19.
file affidavit in reply.
May kindly be fixed date because it is 2019.
Give a date.
bill matter. After 2 weeks,
But did 22 matter? What is it?
no, my lord, not paying that.
7th of
My lord,
34 also same.
my lord. Date, my lord. 34 also says.
34 also Mr. K. Gogoi, same order,
34.
same order.
My lord, fixed on your lord.
7th of June. Yes, where is your affidavit?
See, we have received certain instructions.
Correct, that you have said it in February also.
Lordship, by. Lordship will place it by way of affidavit because it is dealt by my other.
Is it admitted amount?
Lordship,
How much is it admitted?
status of the proposal for sanction of the case. My lord, can be here.
So you have admitted these amounts.
Lordship, on the basis of that instruction, Lordship may dispose of the matter by Lordship.
But there's one bill for the period 1/8/2020 to 10/10/2020
Lordship.
that they say they have not received.
Your Honor, my client has instructed me that they have, during the pendency of the case, they have submitted that.
But this is of December 2022. When did he submit?
That bill for the period of hire was 1/8/2020 to 10/10/2020.
When was it submitted?
It was submitted along with the other bills, but they have again recalled, they have again called the petition during the pendency of the case, and CS submitted on 28/3/2023.
28/3/2023.
28/3/2023. Yes, during the pendency of the case.
This year it has to be submitted. Then you have to get information with regard to the last case.
CS submitted it.
Correct. Heard Mr.
JK.
J.K. Buell, learned counsel for the petition, and Mr. K. Gogoi, learned counsel for the respondent. The matter pertains to the non-payment of hiring charges for the petitioner's Scorpio bearing registration number AS01JC 3339. The Mr. K. Gogoi has submitted letter bearing memo number V/HC dash 111 slash WPC number 7034 of 2022 slash 2022 slash 2790 dated 14/12/2022 issued by the Deputy Commissioner of Police bracket crime, Guwahati, which is addressed to Miss Sumitra Sarma, Junior Government Advocate, Assam, Guwahati High Court, which is to the effect that the higher charge bill submitted by the petitioner against the above vehicle for the concerned periods were duly received, and after the same were verified, the same were forwarded to the sanctioning authority, that is the Office of the Director General of Police, Assam, Guwahati, on various dates. For according sanction of the fund required for payment to the petitioner. Full stop. The letter further states that one bill for the period from 1/8/2020 to 10/10/2020 has not been received from the petitioner. Full stop. However, the status of the proposals forwarded to the sanctioning authority for payment to the petitioner is as follows. You take down this chart. Bill chart. Both sides. Full stop. Next. Mr. J.K. Bhuyan, the learned counsel for the petitioner, submits that the bill for the period from 1/8/2020 to 10/10/2020 has been furnished to the concerned respondent number?
Respondent number, respondent number 4.
Respondent number 4. On 23.
28/3/2023.
28/3/2023. Next. In view of the above letter dated 14/12/2022, wherein it is clear that the respondents have admitted the outstanding dues payable by them to the petitioner, the respondents are directed to make payment of the same to the petitioner within a period of,
In this case, 3 months amount is higher.
within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. In respect of the bill for the period from 1/8/2020 to 10/10/2020, which has been submitted by the petitioner to the respondent number 4 on 28/3/2023, the respondent shall verify the said bill and make payment, if the same is verified, and make payment of the verified amount.
Admitted amount also.
Make a payment of the verified / admitted amount within a period of this one was how much period we give?
3 months.
3 months. Within a period of within a period of 3 months. Within a period of 3 months also. From the date of receipt of a copy of this order. The writ petitions accordingly disposed of.
Allotment kept as a part of the recording.
The letter dated 14/12/2022 issued by the Deputy Commissioner of Police bracket crime, Guwahati, is made a part of the record and marked as an exchange.
Or something.
Today is Thursday. C5 2023. Okay, we'll do it tomorrow. Is the matter of sign, no?
Item number 18.
May I please your lordship? My lord,
Yes,
petitioner, in this case, they are aggrieved because there is no representation of the Chakma tribes in the Barak Valley Hill Tribes Development Council, lordship.
how many Chakmas are there in Assam?
Yes, as per the census report, 4,000. Presently, there are 4,000, lordship. I have stated in paragraph 4,100. As per
They are
2001
Indian, they are Indian citizens.
Yes, lordship.
They are Indian citizens.
Yes, lordship, and as per in Karbi Anglong district, they even they have the forest rights in those areas, in the Karbi Anglong district. So there was one representation of Chakma but he has resigned, lordship. And that his resignation letter is at page 89. One person was nominated by the government.
Heard Miss
He goes, lordship.
D. Ghosh, learned counsel for the petitioner. Petitioners who submits that the notification dated 17/2/2021 issued by the Welfare of Plain Tribes and Backward Classes Department, Dispur Guwahati, should be set aside, as the same is violative of the order dated 19/7/2021 passed by this court in WPC number 1656 of 2011. Correct?
Yes, lordship.
Issue notice returnable in 4 weeks. Who accepts notice?
Lordship, I will represent respond number 6 only, lordship.
Ms. Satin, who accepts notice on the respond number 6? What about the others?
Lordship, WPT Department Standing Council name not shown, lordship. WPT name was not shown, lordship, in the cost list, lordship. Whether copy was served or not, it is also not known, lordship.
Have you served copy?
Yes, yes, lordship, we have served.
WPT copy served or not.
Who is the counsel for WPT?
Ad hoc. That
Huh?
was verify with the sub question.
We have served.
Not served.
Copy was not served, so lordship, that's why he is not retained.
ये तो आगे-
Otherwise also, lordship, if copy is served,
We
then
will
lordship,
serve a copy to him.
You tell them to come.
I'll inform him right away.
Yeah, please. Well, affidavit in opposition has been filed by the respondents, my lord. So matter may be disposed of, my lord.
Huh?
Matter affidavit in opposition has been filed, my lord.
What has been filed?
Affidavit, my lord,
Affidavit has been filed by whom?
by the respondents, my lord.
So,
Matter may be disposed of, my lord.
so we'll dispose it of. What do you want?
My lord, case of the petitioner is that their lands were acquired by the.
Under what law? Acquired under what law?
Under Land Acquisition Act, my lord.
Which land acquisition act?
Sorry, my lord.
Which land acquisition act?
1984, my lord.
1984?
1894, my lord.
1894. When was it acquired?
In the year 2010, my lord.
2010.
Then, my
Then?
lord, due compensation was not paid. They accused this court, my lord, by filing a request. My lord, kindly see the cooperative part of the order, my lord. Page 21, my lord.
Page 21.
Page 21.
Yes.
During the pendency of the writ petition, my lord, matter was referred to the arbitrator, my lord.
Please come to page 22. Please read the order, second paragraph.
Page,
Please read the order, the second paragraph of the order.
page 41, my lord.
22. Where does the order start? In your file, where does the order start? Which page?
Page 22, my lord.
Then please read the second paragraph.
The writ petitioner here in numbering 16 in total has approached this court by filing writ petition with the grievance that their parcel land has been acquired by the National Highway Authority of India for construction of road without following provisions of the National Highway Act 1953 and also without paying.
Without following the provisions of the National Highways Act 1956. Now, you said that it has been acquired under the Land Acquisition Act of 1894. Show me where is the document showing that it has been acquired under the LA Act 1894. No, you have got to clarify. You are saying one thing, something is written, there is something written by this court,
Sorry,
something else is written.
Sorry,
Huh?
sorry, my lord.
So it has been acquired under what? It is supposed to be acquired under the National Highways Act.
Yes.
Is it?
Yes,
Now, what is your grievance?
my lord. Here due compensation was not paid, my lord. They approached this court, my lord.
No due compensation.
Yes.
Then what did this court do?
My lord, then my lord, next page, my lord, paragraph.
Yes.
It appears that during the pendency of the writ petition, matter was referred to the arbitrator for determination of the claim of compensation as per
Under 3G.
3G, my lord.
Then
My lord. Now my last paragraph, my lord. Taking note of the submission made by the Learned Counsel for this writ petition is hereby disposed of with the direction to the respondent number 6, who is the authority responsible for implementing the award, shall take necessary steps for disbursement of the amount of compensation in terms of the arbitral award dated so and so in favor of the petitioner. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 6 months from the date of receipt of certified copy of this order.
Yes, so
Thereafter, we filed a contempt petition since no steps was taken, my lord. During the pendency of the contempt petition, my lord, as per arbitral award, my lord, a assessment was made and it was sent to the PWD minor, PWD department. But during the when contempt petition was listed, my lord, your lordship will find page 41, my lord, order starts from page 38, my lord, contempt proceeding, my lord.
yes.
Contempt was closed, saying that order was only to the deputy commissioner. my lord.
Order was?
Direction was to the deputy commissioner. So, my lord, your lordship kindly paragraph 6, my lord, page 41, my lord.
Yes.
This direction of this court in the writ petition was to the deputy commissioner Hailakandi to take necessary steps for payment of the awarded amount. As the required amount has not been deposited by the requiring department, the deputy commissioner by his communication dated had done the needful for taking steps for disbursement of the amount. The authority in the PWD NH Assam also appears to have done their requirement for informing the authorities in the roads development under Ministry of Transport and Highways Government of Assam. The authorities under the Director General Road Department and Special Secretary to the Government of India, Ministry of Transport is not a respondent contemptor in the contempt, although the said authorities are respondents in the writ petition so and so. In such, we are unable to find any willful and deliberate violation of the order dated so and so by any of the respondent authorities who have been arraigned in this contempt petition. Accordingly, contempt petition stands for. However, the legal rights of the petitioners for being paid the appropriate compensation of the land which has been acquired for the purpose of construction of the still remain, and such right continues remain violated. Accordingly, petitioner are given liberty to oppose the appropriate for disposal of the writ petition. Then this writ petition has been filed. Now they have filed their affidavit in opposition saying that a matter is pending before the Ministry of Road Transport for a approval of the dispersal of payment.
My lord, I am appealing for respond number 1 and 3, my lord. 1 to 3, my lord.
1, 2, 3.
File an affidavit, my lord. That second RC revised cost estimate has already been forwarded to the Ministry for sanction of the amount. I have stated in para 9, Roman 9, my lord,
At 49, my affidavit, my
Yes,
49, Roman 9, para Roman 9.
yes.
It is humbly stated that this honorable court is each order dated 28/8/2018 passed in WPC number 915 of 2015 has directed the respondent authority, more particularly the Deputy Commissioner Hailakandi and the state PWD to take necessary step for disbursement of the amount of compensation in terms of the arbitral award dated 1/7/2018 passed by the learned arbitrator on 1/7/2019. My annex to the petition. The petitioner have stated that the government of Assam has purportedly submitted the second RCE to the
What is RC?
ministry. Revised
RC?
cost estimate.
Revised cost estimate, okay.
The ministry on the 12/7/2000, which was not received by the MORTH, my lord, Ministry of Roads and Transport and Highways, which was not received, which is
Correct, I understand.
but the matter of submission of second RCE by the state government of Assam was not known only upon receipt of the instant petition by the honorable court order, court by memo dated 12/22/2022, regional office of the MORTH Guwahati, by letter dated 22/12/2020 immediately requested the chief engineer PWNH Assam to submit the second RCE, which was received by the regional office of the MORTH Guwahati on 3/1/2023. The same was recommended by the regional office of the MORTH Guwahati by letter dated 4/1/2023 to the MORTH headquarter for sanction. The
So, Mr.
revised estimate I have annexed in my affidavit, my lord. It is 57 annexus C, my lord. And the amount is the last page, my lord. In lakhs.
Huh?
2,0821.21.
28.21 crores, 28 crores basically.
Yes.
So we are not interested in the figures, we're interested in the sanction,
But
the approval. It's under consideration of the ministry.
we have parted it in January last, my lord.
So how long will it take for you to consider?
But the implementing agency is the PWD, my lord. They
Mr.
have not
Council,
submitted
unless
it.
you sanction the amount
Yes.
and you give the amount to the DC,
Yes,
they've got no money to disburse. They cannot give it from their own pocket.
yes, my lord.
They have got to take it from the concerned ministry or from the requiring authority. So
My lord, to the chief engineer PWD NH. They are the implementing agent.
whoever it is. So since it is under consideration with the ministry, as per your affidavit, you please take a decision on this
Yes, my lord.
within 1 month. We'll keep it pending. They want the money. They're not bothered about this figure, that figure, because that award has already been fixed.
Yes.
So there cannot be any change in the figure. The only question is, why are you not giving sanction? Approval for the amount, that's all. Heard, Mr.
AHMR.
AHMR Chowdhury, learned counsel for the petitioner. And Mr. AK Datta, learned CGC, appearing for the respondents number 1 to 3.
1, 2, 3.
1, 2, and 3. First up. The grievance of the petitioner is that despite the arbitrator having made an award dated 1/7/2017 under section 3G, capital G, bracket 7 of the National Highways Act 1956, amounting to rupees 28.21 crores.
0.1.
For payment of compensation for acquisition of the lands of the petitioners. The same has not been given to the petitioners till date. Full stop. The affidavit of the respondents number 1, 2, and 3 in para number 2 bracket Roman 9, small, states that the submission of the second RCE means revised control, revised cost estimate by the state government was known to the respondents number 1, 2, 3 only upon receipt of the present writ petition. The regional officer of MORTH, Guwahati, by letter dated 22/12/22, immediately requested the chief engineer, PWD bracket NH, Assam, to submit the second RCE, which was received by the respondent number
3, my lord.
Respondent number 3. On 3/01/2023. The same was then recommended by the respondent number 3 by letter dated 4/1/2023 to the MORTH headquarters for sanction. The question of sanction for the second RCE is now under consideration in the MORTH. In view of the fact that the consideration for sanction of the second RCE is with the respondents number 1 and 2. Since January 2023, the respondents number 1 and 2 shall take a decision with regard to the sanction of the second RCE at the earliest and preferably within a period of.
It is very difficult because it's a huge amount, my lord. It is sanction.
Land was acquired when?
4 months, my lord. 4 months.
Within a period of 3 months.
4 months, my lord.
A period of 4 months from today. Okay. Period of 4 months from today. Full stop. The time limit has been made in view of the fact that the land has been acquired in the year
2010.
2010. List the matter. How exactly after 4 months you give a date?
Of like
4 months is too long actually.
Yes, my lord.
3 months. 3 months.
Already for last,
Actually, 3 months is also too long.
my lord, for last 5 months, it is already pending, my lord.
Make it 2 months, 2 months, 2 months.
my lord,
Take a decision.
because money is Huge amount, my lord. But government will have to sanction from
Then why did you take away some person's land?
we have not received the second Ashi, my lord.
But you have taken money.
Immediate after receiving the same,
Mr. Counsel, have you read of Article 300A?
my lord, we have already paid the awarded amount to them. But it is a revised, my lord.
Naturally, why? Why revise? Because they went for arbitration due to the fact that they felt that they were given a short deal.
But it is calculated earlier, my lord. Then demanding as per the calculation.
Mr. Counsel, they've been given the said amount as per law under section 3G of the act by an arbitrator appointed by you. An arbitrator is appointed by the secretary to the government. Usually in under 3G, under the government.
Implementing allowances of the PWD, my lord, they have to initiate that cooperation is necessary, my lord. Because they submitted the RC
Within 2 months from the date of receipt of a certified copy of this order.
Obliged.
Item number 18. Lordship. Lordship, I called him, he already left the court premises, so I will serve him a copy.
You have not even served him a copy.
I'll serve him, let it come up on Monday, I'll serve him tomorrow.
Then don't pass any order, just say
Yes.
this is the matter on Monday, on the pair of the petitions counsel.
You are appealing for the
This
respondent,
matter-
we want disposal of the case because not petrol. Due to interim order, petrol pump, work of the petrol pump stall. There any today.
Huh?
Today due to paucity of time, probably, my lord. I see 4:15. We want disposal, my lord.
You want disposal, what is this case?
Basically, your lordship, this matter relates to a petrol pump, your lordship. I am the owner of a petrol pump of the Bharat Petroleum. Your lordship. Now HPCL, Hindustan Petroleum is also advertising a particular petrol pump in that area. So they have violated two specific conditions of the petroleum laws. First and foremost, your lordship, there has to be a stretch of 2 kilometers within a stretch.
Between two petrol pumps.
It's basically two petrol pumps, which are in here, in this case, your lordship, the issue is. Then they came up saying that, no, we have actually by the transport ministry, there is a guidelines. In fact, that has also been violated. And we have filed an affidavit, we have filed the addition, they have filed an affidavit. And also in the, we have in our reply said, they have stated that they have already the petrol pump, which is they are developing, has already been near commissioned. And we have given photographs in our affidavit showing that nothing has been done. Not even the petrol pump, forget about that, just the building has also not been.
Preliminary objection as to the maintainability of the repetition. Look up how he is an agree person. Here the petrol pump. In a Rydell petrol pump was LOI was issued. How he has agreed because he, according to him, his loss of earning. Can it loss of earning be a in view of 1976 Supreme Court, my lord? Therefore, my humble submission, if your lordship take up the preliminary objection as to the maintainability of the repetition on the ground of Lucas.
I will hear you after I hear you.
Yes, my lord. On the ground of Lucas, I have a preliminary objection.
If lordship is hearing the whole matter.
How long will it take?
Will take some time because.
Then I think better to adjourn the
And
matter.
in fact, I would like to point out one more thing, you know, another writ petition has also been filed. 4909, that is in that case, another person who was a participant has also challenged this. I think if that the matter is fixed any other day,
and it may come along with this.
Raise this matter along with WPC 4909 of
2023.
2023.
May I please come? In this case, my lord, I am appearing for Sunda 4, my lord.
Huh.
But I have filed in this case IA for vacation of interim order, my lord.
Or revocation of interim.
Yes, my lord. There is a status quo order, my lord, in this case, my lord. That is why we are unable to construct the, my lord, petrol pump, my lord. So I have filed the IA, my lord. That is, my lord, 509 option 23, my lord. That
I is there, your lordship, along with, it has been listed.
My lord, with this WPC, my lord. My lord, let this I be listed, not in order column, my lord, for estimating.
Why? It is here. How does it matter whether it's in the admission column or order column? In fact, admission column is before order column.
Sir, my lord, let me-
Why do you want to go to the back of the line when you're in the front of the line?
Since my learned friend has asked for hearing the whole matter, why let it be in the orders? Let it be finished of your lordship.
It is in the admission
Yes, yes, exactly,
column
Lord,
right
it's
now.
right.
It is in the admission anyway.
Unnecessary
When you
delay.
go, you have never stood in line for movies earlier. We have to rush to go and be in the front of the line. You want to be in the back of the line. You'll never get tickets. You have to buy in black.
Can I have it on nine?
Huh?
You have to order it.
9th, we've got enough. Too many.
Nine, or
Next week, no chance.
not, then you're looking on 16, my lord.
Okay, list the matter on 16.
My lord.
Along with WPC number.
No, we have set.
Much of. The interim to continue.
Interim order to continue till the next date.
Much of.
My lord, in item 41, they have filed an affidavit in terms of order passed by this honorable court.
We have not received.
So when they file an reply affidavit, it is
Yes.
ready, my lord.
Okay.
Lordship may take up at next week or some day.
Okay, Mr.
Vijay Ghosh.
Huh?
I'm the petitioner.
Yes, Mr. BJ Ghosh. The counsel for the petitioner is granted
My lord,
a week, 2 weeks time.
yes,
2 weeks time to file
Yes, sir.
affidavit in reply. List the matter after 2 weeks.
date may be fixed, my lordship.
What is the hurry? What is the hurry? 23 matter. There's so many matters, everybody wants to do. Other cases will not come up.
Next is your lordship. On the last occasion, the court wanted to know the status of
The appeal.
124.
Yes, what has happened?
My lord, status quo order is operating,
So what to
so
do?
interim should continue in this case.
Well, that status quo order is passed in writ appeal. And
And in this
the
case
impugn
also-
orders are the same.
Huh?
The impugn orders are the same. There were
Ah.
two petitioners. And my lord, one of the writ petition your lordship is already dismissed. So status
So
quo,
my
lord, they have already been vacated. The stalls have been vacated now. And the process of tender is also going on.
I beg
Fresh
to
tender
object, my
is
lord.
also going on. Now status, my lord,
I beg to object, my lord, in that, in this particular case, status quo order is operating because on the first date itself, on 24/3 and 27/3, this honorable court had heard the matter at length, and after hearing both sides, status quo order was passed on 27/3, your lordship.
This WA 124
Yes, my lord,
is with regard to which writ petition?
that is with regard to another writ petition, 18, in which we had challenged your lordship's order, in fact.
this is the writ petition, my lord, which was dismissed
my
by your
lord,
lordship.
in
Which?
The one, my lord.
This one?
Yes.
They challenge this.
Yes,
We have
against that,
challenged
my
this
lord,
before the
they-
division bench.
Yes, and in that status quo order, status quo as it exists today regarding the appellant's license shall be maintained. This was on 27/4, lordship.
Ah.
So my
So-
lord, we have to await the outcome of the division bench and also.
No, status quo is with regard to the,
That petitioner, my lord.
huh? Yes, huh?
Status quo is with regard to the other petitioner.
Deepak and company, and in this case also, on the first date
Since your
itself,
lordship has found one view, my lord cannot defer now. They may file another writ appeal
my lord, in
with this
that case,
party.
your lordship will not take up this matter because in the other
They have to
particular
prefer
case,
another writ appeal in that
yes,
case.
my lord, your lordship had passed the order.
So how does it matter? Where's the bar?
No, my lord, I'm not saying that. In this particular case, status quo order is already operating.
Let me see
And
the order.
he was also present.
This is a single judge order.
Yes, my lord.
You said division bench order.
Yes, my lord. And this
Where is
is
the division bench order?
order.
Deepak instance.
We are today concerned with WPC 1719, lord.
Anyway, there is no time now.
Yes, my lord.
That status quo order was passed in respect of that writ petition, my lord, which have been challenged before the division bench. This is another writ petition, my lord.
And in
My
this
lordship
case,
cannot differ and
No, my
pass
lord.
contradictory orders, my lord.
Correct. It has to be the same order.
Yes,
yes, but
my lord, they can approach before the appellate court again and take the same order. That is different thing, my lord.
my lord, 27(3) in this particular case, already status quo order has been passed. This, he is, my learned friend is talking about.
27(3).
Yes, my lord. In this particular case, we are concerned with WPC 1719 of
Yes,
23.
yes,
And there is an interim order passed by this honorable court.
correct.
Lordship Justice Medhi has passed
Yeah,
that order.
yeah.
My learned friend is talking about another particular case where a similarly situated person had come before this honorable court, and your lordship had passed an order dismissing my writ petition.
Yes,
I had challenged that before the writ appellate court, and in the writ appeal, status quo order has been passed.
status quo order is passed, yes.
So
So,
that's the short point.
but then the order has not been set aside.
No, my lord, it is still at the pending disposal.
Anyway, there's no time
Yes,
now.
my
Due to paucity of time, this is the matter after 2 weeks.
interim status quo to continue.
Interim order to continue till the next. You can take back the order.
Yes, lord. Much obliged.
You want this order back?
My lord, we can give it.
I think there's no time today.
My lord, I have one item 63, my lord.
60?
63.
63, yes.
It is regarding land compensation, my lord. And they have to produce the sell deed before your lordship, whether they have purchased our land by the.
Yes, 63, yes. Anything?
63, madam. Your lordship will be pleased to see the order dated
Any of the contempt petition needs to be closed.
3/4/23.
Give me 63.
Your lordship would be pleased to see the order dated 3/4/2023. Last paragraph, my lord. That they are to produce the sell deed, if any.
My senior lordship.
Sell deed, if any. In proof of purchase.
Yes.
Lordship, in this case, our letter is ready, Lordship, but we have not received the extra copy, so we are not able to send the letter, Lordship. Our letter is ready on 3/4/23, Lordship.
Give them extra copies.
Lordship.
Extra copy is not given.
That is what he's saying.
Extra copy not furnished, Lordship. We have ready letter, Lordship. On
Mr.
3/4.
K. Gogoi, learned counsel for the respondent number
Lordship, I am for respondent 1 and 2, Lord.
1 and 2 submits that. Extra copies of the writ petition have not been provided by the petitioner, and as such, they cannot communicate
Lordship.
the order passed by this court in the absence of copies of the writ petition.
Lordship,
petition-
I am representing, Lordship, respondent 5, Lordship. Five-
Point number 5, not 1 and 2, 1 and
5
5.
and 6, Lordship.
5 and 6. 5.
Lordship.
The petitioner's counsel shall submit extra copies of the writ petition to Mr. K. Gogoi during the course of the, within 2 days,
Not during course, my lord, like this 4,
within 2 days,
2 days.
within
Yes,
2 days.
2 days.
List the matter after 3 weeks.
Lordship, Lordship.
My lord, a date may be fixed. my lord. Because, my lord, our agricultural land has been taken without giving compensation.
Give a date.
Lordship.
Oblige, your lordship.